forward as much as possible. So I'd like to welcome the delegates from today, the representatives of the Republic of Malawi, the Republic of Zambia, the Republic of Namibia. South Africa, Karina, would you be here today as well, or? Yes, please. As it was yesterday, we have about an hour maximum for the four countries to discuss, each about 10 minutes, and then you can have about 10 minutes at the end, 15 minutes there for wrap-up, question and answer, and emerging issues. We have Lady Justice Mwale, who will be our good timekeeper, so please keep glancing around this side. At about 7 minutes in, she will let you know so that you can wrap up. Thank you.
Who's representing Malawi? Oh, you're already here. Okay, so I guess Malawi will start today. I will let you know how much time you have as we go along, but please go ahead.
Thank you, my reader. Good morning to all. For Malawi today, we are to present one case, the Kapinga case. I think there was some confusion. The Skapiza is Zambia. It's not Malawi, but the Kapinga is Malawi. So for this case, the one which is reported is from the High Court, an appeal from the lower court. So I'll start with the facts that transpired in the lower court and move on to the appeal case which is reported. In this case, the appearance in the higher court, they were a brother and a sister. So Joseph Kapinga and Anne Kapinga were a brother and a sister. They had a number of businesses. Among them, they had a maize mill. Now, we had one Jonathan in coma, who was working at their premises, at their business premises, as a casual laborer. Now, in the course of work, this Joseph Kapinga and Anne Kapinga told Jonathan to find for them a person to work in the maize mill. This is a typical case where it is based on witchcraft beliefs. In that part, in our part of, in our country, there are still those beliefs that for somebody to run successfully a maize mill, there should be a person working there. Now, Kapinga told Jonathan to find for him a person to work in the maize mill. Now, Jonathan, at his home, they received a 7-year-old boy who came to live with them from their home village. And Jonathan and his wife agreed or conspired to sell this 7-year-old boy to this Jonathan and Anne Kapinga family for the purposes of the young boy working in the maize mill. They discussed the deal a number of times, and at the relevant times it was Jonathan and Joseph and Anne Kapinga that were discussing the sale, to the point that they agreed to sell this child at 3,500,000 Malawian kwacha. And on the day Jonathan brought the child, he was immediately paid 250,000 Malawi kwacha. When that transaction was done, time elapsed a year or so until relatives started to ask Jonathan the whereabouts of this child. And when he could not explain the whereabouts, he was cornered to the point that he revealed that he had agreed with his wife to sell the child to this family of Joseph Kapinga and Anne Kapinga. Now, the police arrested both Jonathan and his wife, as well as Joseph and Anne Kapinga. They were charged with child trafficking and the Child Care Protection and Justice Act. They were not charged under the Trafficking in Persons Act, which we also have in Malawi, but it was under the Child Care Protection and Justice Act, which also provides offenses for trafficking when it relates to children. When they were brought before the provincial court, Jonathan and his wife pleaded guilty to the charge of trafficking, and they were sentenced to 5 years imprisonment. Whilst Joseph Kapinga and Anne Kapinga pleaded not guilty. Now, trial proceeded in respect of them, and the principal witness was Jonathan, who was able to testify the whole process, how the two coerced him to find a child to work in their maize mill, and why, because allegedly of their poverty or their lack of means, he agreed with his wife to sell the child, and indeed received a sum of 250,000 upon delivery of the child, and expecting that the balance would be paid in due course, which was not paid at all. The trial magistrate, at the end of the trial, found Joseph and Anne guilty as well of trafficking in persons, and sentenced them to 12 years imprisonment. Now, this reported case arises from an appeal of their conviction and sentence. When they appealed, basically, the argument was that the lower court erred in relying on the evidence of an accomplice, who was Jonathan, to convict them. And in the appellate court, the issue of admitting evidence of an accomplice was discussed at length. In our criminal procedure and evidence code, we have section 242, which provides on how evidence of an accomplice may be admitted in court. And basically, it provides that an accomplice is a competent witness against an accused person, and a conviction cannot be merely set aside because it proceeds from the uncorroborated evidence of an accomplice. However, the magistrate or the trial court, what it's supposed to do when it finds that the evidence is coming from an accomplice is just to warn himself or herself that he's proceeding, convicting the accused based on the evidence of an accomplice, and he is aware of the dangers of proceeding in that manner. Therefore, the appellate court upheld the conviction of the appearance, but reduced the sentence from 12 years to 10 years for the appearance. And at the time this trial was being held, the child was not found. It was not clear what had happened to the child, and because of that, the judge also said
Recording in progress.
the state is at liberty to charge the accused persons with murder upon the expiry of 7 years because of the presumption of death of 7 years, that if a dead body is not found, somebody is presumed to have died when a period of 7 years expires. So the state would wait for 7 years. If the child would not be found by that time, then the state would proceed to charge the appearance as well as the accused persons with murder. Basically, those are the facts and the arguments in this case. I think the most important thing as the issues arising in regard to child trafficking, it's a case which the appearance were charged under the Child Care Protection and Justice Act and not the Trafficking in Persons Act in Malawi. Thank you so much.
Thank you very much, Malawi. We move on to Zambia next.
Thank you so much, my lady. Good morning to you all. My name is Dixon Mbao. I'm representing Zambia. I'll present two cases this morning. The first case is the case of Esther Pili. The brief facts in this case were that the accused person deceived the victim whom they were living in the neighborhood. The victim was a child, a girl of 14 years old, who was an orphan and living with other relatives. Apparently, the girl was still in school, and the accused person deceived the girl that school would not take her anywhere, but that she would look for a job, a good paying job in town, that is the capital city of Lusaka. By that time, it was happening in the eastern part of Zambia, Chipata. Yes, after all the arrangements, the accused person moved the victim to the capital city of Lusaka, where she left the victim at the gate of her sister, to be precise, the sister of the accused person, without even introducing the victim to the sister or the would-be employers of her. The victim worked there at the accused person's sister, but she was never paid. Furthermore, the victim was sexually abused by the husband to her employer and the nephew to her employer. The girl was never paid, like I said. And the relatives to the victim who was keeping the girl, they got the wind that the girl was moved by the accused person whom they knew. They continued asking the accused person the whereabouts of the victim, but she refused, having known anything about the movements of the girl. However, the pestering continued, which led to the accused person to move the child from where she had taken her in Lusaka back to Chipata. And in the process, she was apprehended, and the girl child, the victim was gotten from her. After the arrest of the accused person, after the arrest, she was definitely taken to court and tried by the magistrate court. The accused person was convicted for trafficking in person. However, the question which arises is, had it been that the victim was an adult, could have the prosecution had it easy to secure the conviction? The answer is no, considering that the accused person had raised the defense that the victim consented to the movement. If anything, it was the victim who was pestering her that she be moved from the guardians as she was being mistreated. So with that defense, considering that the victim was a child, the court looked at the vulnerability of the child and did not consider how the victim was moved. In the second case, that is the case of Mushenya. In this case, the brief facts are that the couple, that is Musheka Musenya and Matakala, they approached a businessman and advertised their 3-year-old boy. They told the businessman that they were selling the boy because of poverty. However, the purpose of exploitation was not disclosed, but the businessman secretly contacted the police and they arranged to apprehend the accused persons. They moved with the accused persons to the house of the accused persons, where they shot them and gotten the boy who was on sale. They later went to the house of the buyer, a police officer who had posed to be a buyer, and they were paid the money. Whilst they were counting the money, the two were apprehended by the police. The two were charged and arrested for the offense of child selling under the Penal Code of Zambia. And at that time, the section under which the two were charged under, it was repealed, was of the enactment of the Anti-Human Trafficking Act. Apparently, they were tried, and in trial, the two pleaded guilty to the charge. and they were convicted. They were later sent to the High Court where they were sentenced. The wife was sentenced to 26 years with simple imprisonment, and the husband was sentenced to 25 years. They later appealed to the Supreme Court, and one of the grounds they addressed were that they were convicted on the repealed law. The Supreme Court considered the appeal, but the Supreme Court opined that even if the two were convicted on the repealed law, this same section or repealed law was covered in the Anti-Human Trafficking Act, and they opined that had it been that the lower court addressed its mind that the law was repealed, the lower court could have simply amended the charge sheet, and the accused persons, the appellant in this case, could not have been prejudiced, as the court opined that the section which was repealed, under which the appellants were charged and convicted on, was couched in the same way in the Anti-Human Trafficking Act. Suffice to mention that in the repealed law, under which the appellants were charged, the section did not expressly require the purpose of exploitation. However, in the Anti-Human Trafficking Act, the section under which the Supreme Court recommended, it is expressly a requirement that the purpose of exploitation be proved. I should mention that the conviction was upheld by the Supreme Court. Therefore, the question which arises is, how did the higher court consider or upheld the conviction when the purpose of exploitation was not expressly disclosed or proved? Suffice to mention that in the Anti-Human Trafficking Act, the selling of a child is considered to be child labor. Therefore, the purpose of exploitation was child labor. And the court considered that the purpose was considered on the basis that the child was being sold. Again, the other question which begs an answer is, had it been that the victim was not a child, could have the court arrived at that decision, or could have the court upheld the conviction? The answer could be maybe no or yes, considering on the facts. But definitely the prosecution could have found it hard to secure a conviction. Those are the cases I was presenting, and I rest my case. Thank you.
Thank you very much. You've managed to fit both cases into record time. Thank you very much. So we are now going down south. We started in Malawi, and then neighboring Malawi is Zambia, neighboring Zambia is Namibia, and then neighboring Namibia is South Africa. So we'll carry on geographically. Thank you.
And good morning to you all, colleagues. 10 minutes is a very short time for any lawyer to make any meaningful presentation. So due to time constraints, I will not be able to discuss facts of any of the cases I'm supposed to deal with today. I will touch on a few issues because I also cannot touch on all issues relating to child trafficking. And I will use the cases of Lucas, Koch, and Dragon for illustration purposes only. Namibia now has a law, a standalone law on trafficking in persons, and that is the Combating of Trafficking in Persons Act 1 of 2018, which came into effect in November of 2019. Prior to the coming into effect of this law, trafficking in persons was criminalized under Section 15 of the Prevention of Organized Crime Act. Section 15 basically made it a crime for anyone to traffic persons as contemplated in Annex 2 of the Convention, that is the Convention on Transnational Organized Crime. All cases that we have prosecuted so far were prosecuted in terms of Section 15 of the Prevention of Organized Crime Act. By virtue of the way that Section 15 is framed, it allowed us to use the protocol, which is the Annex 2, in prosecuting cases of trafficking in persons. The elements for trafficking in children, because of the way Section 15 was couched, have always been different from those required in cases of trafficking in adults. This comes out in the case of Lucas, where the judge says, thus, I quote, thus to constitute trafficking of a child for purposes of sexual exploitation, all the prosecution need to allege and prove is A, the fact of recruitment, and B, the fact of sexual exploitation. In other words, when a child is involved, how the alleged perpetrator went about doing that is of no moment, and rightly so, close quotation. In the case of S versus Koch, which followed after the case of S versus Lucas, the court stated, and I quote, I come to the conclusion, therefore, that the offense of trafficking a child for sexual exploitation is committed if the child is harbored or received for the commission of any sexual offense known either to statute or common law, close quotation. The case of Dragon, up to now I cannot pronounce the surname of this accused. The regional magistrate followed the decisions of Lucas and Koch and stated, and I quote, all the prosecution need to allege and prove is A, the fact of recruitment, and B, the fact of sexual exploitation. In other words, when a child is involved, how the alleged perpetrator went about that is of no moment, and rightly so, close quotation. We've had another judgment, which is, I'm not expected to discuss, but I'll just touch on it also, relating to the elements of trafficking of children, and that is the case of S versus Pretorius. The High Court in that case also endorsed the finding in S versus Koch. So what I'm trying to illustrate here when it comes to children is that the courts in Namibia have in all judgments recognized that only two elements are necessary when dealing with the case of child trafficking. Another issue that arises when dealing with cases of child trafficking is the requirement that in cases or involving children, their evidence must be treated with caution. And the courts always try to look at the evidence of the child and then also consider that there is that cautionary rule to apply and then look for corroboration for the evidence of children. When we led evidence in the case of S versus Lucas, we were very conscious of the fact that the two complainants or victims were children, and tried to place as much evidence as was available to corroborate their evidence. D and M were 13 and 14 respectively. So we really tried to corroborate their evidence, and this included calling the evidence of the taxi driver that we could get who transported them to Mr. Pretorius for purposes of sexual exploitation. The court in S versus Lucas commented on the fact that D and M had lied when they spoke to the school authorities. The judge went on to find that it was clear that at the stage when they spoke to the school authorities, M was genuinely ashamed of what she had done and appeared confused. The judge concluded also that M initially told untruths due to childish confusion. He found regarding D that she had lied because she wanted to continue enjoying the benefits that she was getting from Pretorius. The court also acknowledged that there were inconsistencies in the evidence of D and M, but fortunately found that those inconsistencies were not material and did not detract from the veracity of the evidence of D and M. The court still went on to look for corroboration for their evidence, which it found, including in the evidence of the accused person herself. In the matter of S versus Koch, the court also applied the cautionary rule and found that due to the contradictions in the evidence of the children, even in respect of incidents where they were together, the guilt of the accused in respect of the charges of rape could not be sustained. The Supreme Court, because we appealed this judgment, on appeal agreed with the finding of the trial court in this regard. Fortunately for us, the court, that is the trial court, still found that from the evidence it had been proved that the accused had contravened Section 14C of the Combating of Immoral Practices Act for soliciting children below the age of 16 to the commission of indecent or immoral acts. In the Dragon case, the regional court magistrate convicted the accused on 3 counts relating to a child who had refused to answer questions in cross-examination. She gave evidence in chief, but very briefly. But when she was questioned in cross-examination, she refused to answer completely. But the regional court magistrate convicted the accused on those charges relating to that child. The lawyer for the accused launched an appeal on his behalf against the convictions in respect of those charges relating to the child who had refused to answer questions in cross-examination. We argued on appeal that the 5 minor children had been together at all times when the accused sexually exploited them. The other children had given evidence regarding the sexual exploitation of W, the child who had refused to answer questions in cross-examination. The judges on appeal accepted our argument and confirmed the conviction of the accused in respect of the counts relating to W. Another issue that I have noted relating to cases of child trafficking is relates to coaching. Judges seem to look out for likelihood or pointers that the child could have been coached to come to court and say what she is saying or he is saying. In the case of Koch, the judge was concerned about the likelihood that the children could have been coached. The judge, in fact, went on to conclude that NG, one of the children, could have been coached by her mother and her aunt. This was one of the grounds upon which we appealed the Koch judgment to the Supreme Court. Fortunately, the Supreme Court agreed with our argument that the fact that the evidence of NG contained much more detail than that of her mother and aunt ruled out the possibility of coaching. The Supreme Court also accepted the argument that the fact that another child who was in a different town when the allegations surfaced told her mother a version of events similar to that of the other children ruled out the possibility that NG was coached. Another issue that we have faced relates to the framing of charges. I'm trying to raise, Madam. Oh, thank you. No, but I will try and do the 10 minutes. The other issue. I'm indebted. Yeah, the issue relates to the framing of charges. In the case of S versus Koch, the prosecution was criticized in that judgment for the way that the charges were framed. The judge found that the way that the charges were framed was prejudicial to the accused. At the time when the allegations surfaced, the children had been going to the residence of Mr. Koch on numerous times for 6 whole months. None of them could provide specific dates. All that the prosecution had was that the many incidents of trafficking and sexual exploitation happened between November 2015 and March 2016. And the only recourse that was available to us was to invoke the provisions of Section 94 of the Criminal Procedure Act, which allows for the charging of an accused person with the commission of an offense on diverse occasions within a period of time. So this is one of the issues that may arise for you as well. Another issue related to the evidence of sexual exploitation. Children, in my experience with these cases, seem to have a challenge to explain what exactly was done to them in a manner that the court understands. In the Koch case, for example, all the 5 children described how the accused tried to insert his penis into their vaginas and it slid through to the buttocks. He had applied baby oil. Unfortunately, all the attempts to get them to better explain what they meant by he tried to insert and then it slid through the buttocks yielded no desired results on our part. That is one of the challenges that we faced, and that is possibly one of the reasons why we could not get a conviction on the rape charges. Another issue relates to cross-examination. Cross-examination is very challenging for all witnesses, especially children. In Namibia, cross-examination of children below the age of 13 years, in terms of the law, must be done through the court or a qualified person appointed by the court. The court can simplify or rephrase the question so that the child understands what they are being asked. The judge in S versus Koch actively made sure that the children understood what they were being asked during cross-examination. I just, as I conclude, want to refer to a good practice which I believe we all need to take note of. A court dealing with, fortunately we have a judge in our midst, a court dealing with a case of child trafficking must be sensitive to the needs and emotions of the child. In Namibia, the law allows a support person to sit with a vulnerable witness during their testimony. Children below the age of 18 years are categorized as vulnerable witnesses. If a child feels comfortable, they are more likely to give evidence that will assist the court in coming to a just conclusion. The judge in the matter of S versus Koch, who was the same judge who dealt with the case of S versus Lucas, although he was very impatient with the children in S versus Lucas, it looks like he had a better understanding of the offense of trafficking when he dealt with the matter of S versus Koch. He was very patient and accommodative of the children. Okay, I'm finishing, thank you. He would constantly check whether they were still okay, and if they wanted breaks, he would grant the breaks. By way of example, NG, the youngest child in the case, is a very open child. She testified longer than the other children. And during her testimony, the support person told the court that she wanted a bathroom break, and that was granted. When the court resumed, the judge asked her whether she was ready to proceed. She answered in the negative, and when asked why, she told the judge that she wanted to sleep. As a prosecutor, I obviously cringed because I thought the judge was going to get impatient with the child. But instead of being annoyed, he asked her whether she wanted to go home to sleep and return the following day. But NG then said no, she wants to sleep on the couch in the victim-friendly room. The judge adjourned the court for 2 hours to allow her to sleep, and she did fall asleep. I believe it is important to highlight some of these things that unfortunately do not become part of the judgments that we read, and unfortunately also cannot be part of our case digest. Thank you very much, and sorry for exceeding my time limit.
Thank you very much. We definitely needed to hear those very specific and important details. So we now move next. We're crossing the border into South Africa.
Good morning, colleagues. I couldn't find, I'm supposed to discuss Msweli. I couldn't find much about Msweli, and it seems like Msweli was also convicted in terms of the previous legislation, the Children's Act, for illegal adoption. So what I'm going to, and that was repealed, that act was repealed by our current TIP Act in August 2015. So what I'll do is, I've discussed it with Madam Chair, and she's in agreement, discuss the cases that are actually mine. So one of them that is, you can maybe, if you have my slides.
Would
so
a tech support assist us with South Africa's
one slide.
PowerPoint?
But in any event, slavery, one of the child trafficking exploitation methods is for slavery, and that normally happens when the child is being sold. Because slavery is defined in our act as reducing a person by any means to a state of submitting to the control of another person as if that other person was the owner of the child. And in Kutzer, State versus Kutzer, it's a case that I did. We got a conviction, I think it was January this year, where the accused pleaded guilty. This is a female accused. She got accommodation. The victim's father actually offered her and her mother accommodation. They were not romantically involved. That makes this whole offense even more heinous. The fact that the father actually accommodated her out of kindness, and then she sold his child. Well, she attempted to. She approached a person that was known in the community as dealing with stolen goods, etc. So she approached him and she said to him, he must find a buyer, a Nigerian buyer, for this 13-year-old child of this friend with whom she resided. The child was also resident with her father. I think the mother had passed away. In any event, luckily for this child, this person then informed the police, who then started an operation, a trap, in terms of our legislation, and a policeman then acted as the buyer. She sold this child for 40,000 rand, and after the sale, she was arrested. We arrested her mother as well, because during the sale, she indicated that her mother was aware of what was happening. Her mother had also disposed of the 2 cell phones, because she took the child to the shop, and she wanted to pretend to the father of the child that they were robbed and the child was stolen from them. And to motivate this claim, she got rid of the 2 cell phones, her mum's and hers, and then her mum did that. And in our legislation, if you want to rely on a prior agreement, you must either be able to submit evidence indicating when that prior agreement was concluded, or you have to submit evidence that all your accused actively participated in the offense. Now, despite the fact that the main accused did all the arrangements for the selling of the child, the mere fact that the mum got rid of the cell phones was active participation in this act of trafficking, and therefore she was charged as well. And we deliberately did that because we wanted to force this accused into a plea of guilty. And she said from the beginning that she doesn't want her mum to go to prison. We denied bail for both of them, so they were arrested in the winter of last year and convicted this year. So they spent several months in prison before their conviction, and she eventually pleaded guilty as well for 20 years in prison. But the child was severely traumatized. It was a very protected child, very poor, but still very protected. And this whole event and the fact that the child almost was sold into a sex ring really traumatized the child severely. The child was also taken from the care of her father, who was also traumatized. I think I mentioned that yesterday, but that is something that we really do have to take into account, is that it's not only, the trauma is not only your primary victim. Very often there are numerous secondary victims that also experience the trauma. So just for the father to also come to terms with what had happened, the child was removed from his care for about 6 weeks. And that increased her trauma. We placed her back because we realized actually that the trauma that she, due to that separation, suffered. So, but in any event, so we knew the child wouldn't be able to testify, at least not very soon. And so that was why we also sort of push the accused into a plea of guilty, and we withdrew the charges against her mother. Okay, the other case that I did was child labor. These were 2 children that came from Lesotho. They were recruited by a family member to come and work for family in South Africa. They considered the whole trip to South Africa to be an adventure. They weren't schooling in Lesotho due to a lack of resources, so they saw also an opportunity for a better life coming to South Africa. When they arrived, luckily for them, when they arrived at the taxi rank in Pretoria, the accused had not arrived yet to pick them up, which caused the children to actually engage in conversation with taxi drivers at the taxi rank. When they informed the taxi drivers that they are in South Africa to work, to be employed, the taxi drivers, of course, immediately phoned the police, because in South Africa, children of that age, they really looked like children under the age of 15, and we have strict labor laws where children are not allowed to do any form of labor under the age of 15. In fact, even children that appears in advertisements on TV and in movies, whatever, they need permission either from the head of the Department of Labor or the senior prosecutor of that jurisdiction before they can actually be utilized in advertising. But yeah, be it as it may, so no children under the age of 15 are not allowed to perform any form of labor. So taxi drivers luckily knew that. They phoned the police, and these people were arrested. So their exploitation never took place. But the intention definitely was to employ them. So that would have been child labor. And after their arrest, we also found pamphlets in the car with which that the accused used to fetch the children, advertising an event at a tavern that would have lasted the whole night. That event was advertised for 2 days after the arrival of the victims. In other words, from 6 p.m. until 6 a.m., they would have had to work at that event. The children claimed to have been 14 when they arrived in South Africa, but because they also arrived with any documents, so you can imagine also if they were not reported, if the taxi drivers did not find them and did not report their presence in South Africa, they were undocumented because they were unaccompanied. They walked over the border. No one would ever have known about them. They would have just disappeared in a black hole, because the mere fact that they were also undocumented in South Africa mean, where do you start looking for them? And as I said, their parents were complicit in their trafficking. That's specifically their parents that took them to the recruiter, that brought them to South Africa. But because they were undocumented, they had to cross the border on foot. But in any event, child labor in South Africa is described as work by a child, which A, is exploitative, hazardous, or otherwise inappropriate for their age, and B, places at risk the child's well-being, education, physical and mental health, or spiritual, moral, emotional, or social development. In South Africa, a child has to school until the age of 16, so any employment during the day when the child should be at school would be inappropriate, or would place the child's well-being, education, and mental health, emotional and social development at risk. So, as I said, any labor really would qualify, but as I said, the children also lied about their ages, and we had to do, but in the event we didn't have a birth certificate, so the children was examined by a stomatologist who was an expert in dental research and forensic orthodontology, and he does the age assessment with radiographic analysis of the teeth present in the maxilla and the mandibula. So yeah, so he discovered that the children were 12 years old. Eventually the defense actually did submit a birth certificate, but it was a birth certificate indicating that the child's birth was only registered and reported by the grandmother 2 years before the child traveled to South Africa. In other words, many years, about 10 years after her birth. So I argued that this birth certificate was inadmissible because it was based on hearsay. We don't know how the grandmother knew when the child was born, and if the grandmother was present and relied on her memory, we don't know whether her memory was correct. So it was inadmissible. We are going to get judgment in April. So yeah, let's hope, hold thumbs. As I said, the case is still ongoing. But this is a case of child labor, that the exploitation had not happened yet. The accused, of course, argued their defense is that they didn't know that these were children that were coming to South Africa to be employed. They thought they were employing adults. Then in terms of the servitude, I also just want to bring under your attention a case called Fakutsi. Fakutsi was convicted for trafficking for sexual exploitation. On appeal, Fakutsi was acquitted on trafficking and only convicted for rape. So the sentence remained the same, but still the trafficking conviction did not stand on appeal. However, the way that I read the record, I do think that if Fakutsi, what I did with Kutser, I charged with exploitation, the intended exploitation to be slavery because the child was sold, and or sexual exploitation because the child was sold for sexual exploitation. But I was worried that I might not prove the intent for sexual exploitation because the exploitation had not happened. That is why I think Fakutsi probably would have been able to, the conviction on trafficking probably would have succeeded if Fakutsi was charged with sexual exploitation and or servitude, because servitude is defined as labor or services that are provided or obtained through threats of harm to that person or another person, or through a scheme, plan, pattern intended to cause the person to believe that if the person does not perform the labor service, she would suffer harm. Now, what happened in Fakutsi? It was the child that was abandoned by her mother in the care of her stepfather. He then, because of the mum's abandonment, he was South African. They were living in Eswatini at the time, and he wanted to return to South Africa with his 2 children that he had with the victim's mum after the victim's mum's disappearance, but he didn't want to take the victim with. She was scared that she might end up on the street, and eventually begged him to take her with him to South Africa, which he eventually did. From the beginning in South Africa, he started utilizing her as basically his domestic help, or as she described it, he used her as mother and wife, mother to his children, his other children, her half siblings, and later as his wife. But the reason why he was acquitted for sexual exploitation is the sexual exploitation did not commence immediately on arrival in South Africa. I think he waited about 2 months before they came to, at the end of 2014, and the sexual exploitation only started in the beginning of 2015, so some 2 months later. And the court found that could not, therefore we could not say that was his intention from the beginning for bringing the child to South Africa. But, however, the trial testimony was that from the beginning she had to look after her younger siblings, she had to do all the household chores, and as she was described as being a parent to them. And I get the impression from her evidence that the father was not a very caring father or a very present father either. And the victim was forced to do this so that she could go to school. Otherwise, he wouldn't allow her to go to school. Now, to me, that falls within the definition of servitude. Another servitude where I think, in terms of where we can apply the exploitation form of servitude, is with drug mules. Because in all our drug mule cases in South Africa, where South Africans, and very often it is the young ones that they use, maybe not under the age of 18, but definitely the drug mules that are often being used by drug dealers or traffickers would be under 24 years old. And what normally happens is these children are being sent for whatever reason to Brazil, to China, to Taiwan, and they are told once they arrive there that they are only ever going to come back home or very often they get sent to Brazil, they get told there you are going to be locked up until you take this batch of drugs to Taiwan or to China. And you can say that that might just be a defense of these drug traffickers or whatever, what you call them, drug mules, when they get caught. But eerily, we have taken statements from people that ended up in Thailand, that ended up in China, that ended up in Brazil. They all refer to the same Nigerians that sent them. They all have the same story. But as I say, not just the same story, the same names of the people involved. So there must be some truth in it. So if your legislation reads the same, just remember that a drug mule falls within the definition of servitude. Illegal adoptions, as Msweli was illegal. Msweli was actually kidnapped. The child in Msweli case was kidnapped and then sold to a couple that wanted to adopt him. They thought they were legally adopting the child from a social worker from social welfare, but in the meantime they were actually adopting a stolen child. But previously, for illegal adoption, you did not have to prove that the purpose was for exploitation. Now we have to prove the purpose is for exploitation. However, Msweli's child was 2 years old and he was bonded to his family. He lived with his mother, he lived with his father, he lived with his maternal grandparents as well. And he was then sold to a couple, though they loved him and he lived with them for 5 months. They did not abuse him, they loved him, but the fact is it's very, very abusive to remove a child from a bonded relationship. Doesn't matter how much you care for that child will always suffer that trauma. And I've seen research on sex offenders, convicted sex offenders that offended against children younger than 7 years old. In other words, the oldest child was 6 years old, and all of them have one thing in common, and that is abandonment, maternal abandonment. So that, the harm done to that child is immense. Okay, and Ukutwala, Gisele, I just want to say that in forced marriage, we have a customary, a legitimate cultural practice called Ukutwala, but we have heard evidence in Gisele that said the minute that consent is absent, then it's no more Ukutwala. Now it's a criminal offense of trafficking. And yes, we can't get to sexual exploitation. My time is up. Thank you.
Thank you very much. I'm so sorry that you've had to cut it short. These are all very exciting issues. I'm sure you'll all agree. The presentations have all been very unique in their own ways. But one common thread that I've noticed is that there are quite a number of technical issues that we may need to take note of. So if we start with the Malawian case of Kapinga, we see that on appeal, issues of evidence of an accomplice were raised. So you have that cautionary rule coming into effect. And like all the other countries, as long as the tribunal of the trial court warns itself of the potential dangers, that will not succeed on appeal. But this is just showing us that, there will be defenses and there will mostly be technical issues. So we need to be very prepared about that. The same is evident in Mushenya. We have the technical issue that a repealed law was used during the conviction. I find the Supreme Court of Zambia very, very bold in this case, because I would never have expected the Supreme Court to uphold a conviction on a repealed law. So that's a very interesting case to cite on how, if the elements are similar, the Supreme Court held that it was pretty much the same offense. So that takes us back to the issue of, when charges are being drafted, what precedent does that mean now that, every time you draft a charge and there are two very similar offenses, you can succeed on conviction of either? Those are interesting issues that we can, look at further. In Namibia as well, we were not short of technical issues. You have the evidence of children, where the cautionary rule again was applied. Now, children can lie, yes, and this is an issue on which a case was overturned on appeal, because the judge was convinced the children were lying. So the whole issue here is, yes, children do lie, but then so do adults. And sometimes these rules, like the cautionary rule in corroboration on women lying in sexual offenses, is just the same as assuming that all children lie because they're children, or all women lie in sexual offenses. So there are all these technical issues that we have to consider and present to the court, that sometimes, they need to break away from biases. Just because it sounds like this doesn't mean that it is like this. And that's where, a background of the case is so important for you to understand child trauma, so that the court can be convinced that this isn't coaching, but it's, probably trauma or vulnerability influenced. Other issues that have arisen. I'm still looking at all the presentations. So we notice in Kapinga as well in Malawi that one of the issues that was raised was that the trial was held in a prison. So the accused persons, because they had made this child disappear, and everybody understood in the context that when you say you need a child for a maize meal, it means you kill that child so that you can profit in your business. So the community was very enraged, and they camped around the court, and they were going to mob or lynch. Mob justice was going to happen to this couple. So the court decided to hear the case, not in a court premises, but at the prison, so that the accused persons could be safe. But they appealed on a technicality to say we were not convicted in a court of law. So there are always going to be issues of victim or accused person protection that we may need to consider. Where can a trial be held? And they did not succeed on this ground because, there are provisions under our Civil Procedure and Evidence Code about where trials can be held, and this was not in breach, and it didn't prejudice the accused person's rights in any way. Zimbabwe, the case of Piri, issues of consent. We've been talking about consent quite a lot. Can a person consent to being enslaved? I think we've already dealt with it, but it proves the point that Rahel made at the beginning, that consent is always a live issue. Whatever case you're dealing with, consent will always creep in. One last point that I will note as a salient feature is prosecutorial strategy. We've seen quite a lot of it in the presentation made by South Africa. You have a child who wasn't probably going to be a good witness, wasn't ready to testify, and so the prosecution team made sure that the accused person pleaded guilty. So in as far as that can be done, it's so difficult to count your losses. You convict one person, you prosecute one person, but you don't prosecute the other, just so that you get the desired effect and the child doesn't have to testify. So that's an example of prosecutorial strategy to prevent additional trauma to the child. And Namibia showed us judicial strategy, where the court was very willing to oblige the prosecution request that the trial be adjourned for a child to fall asleep. I can imagine how many of us would be annoyed. You're sitting there, you are all robed, and then the child tells you they want to go and sleep. But that's such a brilliant example that comes out. And as Advocate Nyoni said, you don't see this in the case record. And so that's why our sharing these experiences is so important, because we get the story behind what it is that we're looking for. It's also interesting to note proving exploitation. That's been a very topical issue these previous, from most of yesterday, we've talked about the differing approaches that courts have about proving exploitation. And it's very interesting to hear from South Africa that once you have an illegal adoption, exploitation is proved. Even if you're looking after a child very well. So we all, mostly, to some extent, this is Southern Africa. We can all say that we have very impoverished communities where children would be better looked after in the West. And there are so many inter-country adoptions happening. Not all of those might be in good faith, and the child might be very well looked after where they're going. But the fact that there's some illegality concerned is exploitation on its own, and that's what we're learning from South Africa, that, just abusing that process causes trauma. Maybe the child has been separated in a way that should not have happened. So thank you very much. I'm not going to have questions at this point. We're going to have our next panel come in straight away after we've given our colleagues a very big round of applause, and then we'll have question and answer. So let's invite to the podium our next panel. I believe we agreed yesterday that we would forego the tea break for now and have both panels so that we can finish in good time. So I'm inviting Lesotho, South Africa, and Zambia. So we will start again with we'll start with Zambia, and then because you're last in the alphabet, you always end up being last. So we'll make sure you start. you start this session. So basically, this session we're looking at Chapter 5 in the Regional Case Digest. We're looking at steps to protect victims. We've had snippets. We've had very good practice from, is it the DRC? So today we're going to carry on with that. How can we protect victims? Over to you, Lesotho. Over to you, Zambia. Please keep your eye towards the front as you speak.
Okay. Good morning, colleagues. We'll be discussing the case of Joshua Mutwale. In this case, the accused person was a Congolese national who was living in Lusaka, which is the capital city of Zambia. This gentleman was communicating with Mr. Jackie Saidi, a friend who was a Congolese as well. And during this conversation, this friend indicated to the accused person that there were people traveling from DRC to Lusaka, and that he was there to help them cross over to the Republic of Namibia. So along the way, the accused received these 5 children who were moving with a lady, and this lady claimed that she was the grandmother to these children. They stayed together with the accused person in Lusaka for 5 days. And during this period, the accused person arranged for the travel documents and left together with the children and the same lady proceeding to the Republic of Namibia. However, they were traveling, the immigration officers got information that there was a lady in the bus that was going to Sadc, and this lady was traveling with 5 children. The suspicion was that this lady had trafficked the children. So the immigration department tipped the police, who went and mounted a roadblock, and the accused person was apprehended, taken to the police together with the children. Whilst they were at the police station, the children could not respond to the names on the passport and informed the police through the interpreter that their names were different from those appearing in the passport. It was at this stage that the accused person was arrested for aiding, contrary to Section 11 of the Anti-Trafficking Act, number 11 of 2008. The accused was taken to court, and in his defense, he stated that actually he was just helping those kids because there was a war in DRC. So according to him, he was helping the kids to go to Namibia. However, accused was convicted, and the court relied on the evidence that accused had kept the children and the grandmother for 5 days while processing the forged passport. The court further found that the accused prepared the forged documents and that he was paid by Jack, the friend, to facilitate the moving of the children with their grandmother from Zambia to the Republic of Namibia. When you look at the facts, you would find that the court relied heavily on the preparation of the document that this accused person was aiding the children to be taken to the Republic of Namibia, and that he also received some money for the job done when he prepared those documents. When you also apply your mind to these facts, you realize that the children were intercepted before they were crossed over to Namibia. And the facts are silent on the type of exploitation that was going to take place in Namibia. However, when the accused person was convicted, the children were taken to a safe place by help of the Ministry of Community Development and Social Welfare, where they were kept for some time, and then the department facilitated their movement back to their origin, their country of origin. Apparently, these are the facts and what occurred in this case in a nutshell.
Do you have the sentence? Thank you very much. We have Namibia, South Africa next, and we'll finish with Lesotho.
Good morning, colleagues.
Tech support, I think we have another presentation. We're just looking. If anybody has seen the remote that moves the presentation around.
Right, colleagues, I will proceed while my colleague will be dealing with that. So, obviously, you have a trafficking case has been opened now. Your victims has been rescued. They are in a place of safety. Now the question is, what is the next step? Is there protection for victims when the court process starts? And how are we protecting our victims? Now I will highlight this in the two cases that I'm going to deal with, and that is the state versus Mabuse and then the state versus Martini. Now just a brief summary of the evidence in the state versus Mabuse. In that particular case, the accused was charged with another person, co-accused, which a female, on various charges relating to tip, and then also charges of rape. Now the victims in this particular case were 4 children, and the ages were between 11 to 13. The allegations that was preferred against the accused was that over a period of 3 years, that stems from 2009 up until 2012, that they unlawfully trafficked the 4 children from Mozambique to South Africa. Now, how did that happen? The victims were recruited by a person by the name of Aunt Juliet, who is the sister of accused number 2. This person, Juliet, deceived the parents of the 3 children by telling them that the children will be visiting family in South Africa, and also promise that once they're in South Africa, they will get better education. The 4th child was abducted when this Juliet misrepresented to the child that a grandmother gave permission for her to come to South Africa, which was clearly not the case. Now, because none of these, the children had valid passports, they were then smuggled through the border fence between Mozambique and South Africa on different occasions. They were taken to a village near Plantation, which was so remote and which could only be reached by bad dirt roads. They were then taken to a small house not far from where accused number 1 was staying. And then accused number 1 would then on different occasions come to the house and rape them, or they would be taken to his house by either the co-accused, accused number 2, or this person by the name of Juliet. Accused number 1 would then pay money to either accused number 2 or Juliet. The children, when they testified, they told the court that the accused would sometimes fetch them with his red vehicle. The accused confirmed that he had a red Jeep vehicle. They further told the court that the accused would smear a white ointment on their private parts before raping them. Now, obviously, during the trial process, the court is hearing this evidence, and the court decided that the court, ACWO, is going to go for inspection in loco to see how this exact point is where the children were smuggled through the border, and also to see the conditions in which the children were kept. That is obviously to assist the children when they gave evidence during the trial. And that is one of the procedures that we used in our criminal cases to give the court a better view of evidence, the evidence that is led by the state. Now, whilst the children were supposed to now testify, the state then brought an application for the child witnesses, their evidence to be heard via an intermediary. The state, in support for the application, relied on the report of a social worker who made an assessment of the child witnesses. Now, in this case of Mabuse, the social worker were Ms. Maseku, who interviewed the children, obviously for the purpose of determining whether the intermediary should be appointed when they gave evidence. The application by the state was not opposed by the defense. Now, when one look at the case of Mutini, the matter also involves 2 female child witnesses that were trafficked by the accused. A further challenge in this particular matter is that the 2 child witnesses were mentally challenged, and the mental ages were between 9 and 10 years old. They were then deceived by the accused into making the 2 girls believe that they have promise of employment and that their parents agreed to them accompanying the accused. There was a further allegation made that accused number 2 was related to one of the victims. The 2 victims were raped and repeatedly sexually exploited by different men in exchange for groceries like meat, soup packs, paraffin, and cigarettes that would always be paid to accused number 1. This lasted for about 3 weeks during the school holidays in July in 2012 until the girls managed to escape. It was only after the disappearance of and the rescue of the last 2 victims that it was discovered that accused number 1 had been running a house in Tlatini as a brothel since April 2006. The 2 accused in this Matini's case were both female accused. And she had over the years trafficked many unsuspecting and vulnerable victims to Fairview for sexual exploitation purposes by means of deception about prospective employment there. The earnings, which is mostly in the form of groceries, derived from this exploitation was used to supplement income. Now, despite the 7 victims that the accused has been convicted of, the evidence revealed several more victims that had fallen prey to her actions and thus formed part of the pattern of racketeering. The evidence showed that she had even sold her own daughter at the tender age to several men in Fairview that resulted in her contracting HIV and obviously passing away because of that. Accused number 2 was also a victim of accused number 1 and can thus be described as a happy trafficker in order to have one summary trial, racketeering was an excellent tool to use in this particular prosecution. Now, the challenges that was there in Martini's case was obviously we're sitting now with two victims that because of the mental challenge that they faced, they suffered mild and moderate mental retardation and thus had no concept of time, chronology, abstract concepts, and the cause and effect. The state then also in this particular matter applied in terms of section 117 capital A to lead their evidence through the use of intermediary and a CCT, TV camera. This application was opposed, but obviously it was granted by the court. Now, what is section 170 capital A of the Criminal Procedure Act? This is just one of the tools that we used in our, during our court proceedings to offer protection, especially for our child witnesses. Now, section 170 briefly says the following. Whenever criminal proceedings are pending before any court, and it appears to such court that it would expose any witness under the biological or mental age of 18 years to undue mental stress or suffering, if he or she testifies at such proceedings, the court may, subject to subsection 4, appoint a competent person as an intermediary in order to enable such witness to give his or her evidence through that intermediary. No examination, cross-examination, or re-examination of any witness in respect of whom a court has appointed an intermediary under subsection 1, except examination by the court, shall take place in any manner other than through that intermediary. Now, obviously, when one reads this, the question of prejudice comes to mind. Would there not be any prejudice towards the accused? But with regards to what is the intermediary, is it a remote, far off place or section in which the child witness will testify? That is definitely not the case, especially with this procedures. What normally happens is you have the court, the open court, and sometimes there would be an adjacent room, child-friendly, where the child and this intermediary, which the court will then appoint, would sit. There would be a camera, cameras and obviously a TV in that room as well as in the court itself. So when the process starts, the TV inside the court will be switched on. The court will observe the victim, the court will observe the intermediary, and also all the other role players. Therefore, the accused will see the victim, the defense advocate or lawyer will see the victim, the state sees the victim. So the demeanor of the victim can be witnessed by each and every person inside the court. So the question of prejudice, and I mean that is what we always submit, is that there can be no prejudice for the accused because the room in which the child is testifying is regarded as the same as the courtroom. And obviously one needs to protect your witness, because imagine you're already traumatized because of what happened with you. Now you have to come into a court that is completely unfamiliar, which is foreign. And even for us as practitioners, we are used to the setup of being behind the bench. But when you have to go and stand there in the witness box, that's a completely different picture. So just imagine you're a young child, you're exposed to a complete different environment. That in itself can lead to undue mental stress or suffering. And that is what we as practitioners and lawyers need to protect our witnesses from. Now, section 170 capital then further sets out, what is the requirements that the state needs to meet before, an intermediary can be appointed. again, the intermediary, in the act itself, the act sets out who is this persons that can be appointed as an intermediary, and that can be various persons. It can be medical practitioners, it can be social workers, it can even be teachers. It depends on the experience and the qualifications of that particular person, because obviously when the person compiles the report, this person will set out the experience in detail in the form of a CV. And mostly, and in most cases, the courts will appoint an intermediary to assist a child witness during their evidence. As indicated, that Section 17A is but one of the tools or aids that the prosecution can use to protect victims against secondary trauma. With that also, we have Section 153 in our legislation, which basically says that the court would be in camera, and that would exclude the public. Then Section 154 is the prohibition of certain information relating to criminal procedures. The court can make an order and say the name of this victim or the name of this child must not be disclosed by any person. That is also a way in which we can protect our witnesses. And this was in both the Mabuza and Martini's case. This procedure was applied for and it was used by the prosecution. But is there other methods that we can use? Obviously. Again, when a defense lawyer asks unfair questions to your witness, you as a prosecutor needs to stand up, you need to object and protect your witness against that unfair bullying tactics. And that is also what happened in Mabuza as well as in the Martini case. And the way that lawyers pose their questions obviously is in a manner to confuse child victims. And therefore we have another process, it's called re-examination. You re-examine that witness, child witness, to clarify those issues that the lawyer tried to create confusion for the witness. And it may sound trivial, but you've got a witness that is extremely emotional. What do? Are you just going to say to that child witness, continue with your evidence? No, we're not going to do that. You ask the court, please, can we adjourn? Can we afford this witness an opportunity to compose him or herself? Because obviously that in itself, to sit there and to allow a witness to continue with evidence, knowing that this witness is extremely emotional, would not be fair to that particular child witness. I know my time is almost up, just one aspect. Then obviously during sentencing, the sentencing stage, there's also further protection that can be afforded to our victims of trafficking by the court in terms of the sentences that the court can impose. That is obviously, in terms of giving heavy sentences to prevent future perpetrators, and that will also prevent new victims to fall prey to this kind of horrific charges. And just to highlight that the role of the public in assisting trafficking cases is also important. It can either positively or negatively impact on a victim of trafficking. In the Mabuza's case, the one victim was rescued after she was taken in by the wife of the accused number one. And in Martini's case, both the negative and the positive aspects of the community was highlighted. And this was also emphasized by the magistrate during his judgment. Thank you, colleagues. I think
Thank you very much, South Africa. I hate to have to stop you. There's so much that we're sharing, but we will have an opportunity to go into more detail at some point. So Lesotho, over to you.
Thank you. Can I put my mask on? Is it okay? I have a sore throat, so I don't want to infect anyone. So I'm going to discuss a Yusuf Gemei Tesfagaba. So I'm not going to say that again because I can't pronounce that. I'll just say the Yusuf case. I'm going to discuss that in connection to victim protection. The facts of the case are as follows. The accused couple acquired citizenship after coming in Lesotho as refugees. They jointly owned a restaurant in Maseru. So the accused couple was charged with contravening Section 5(1) of the Anti-Trafficking in Persons Act of 2011. The victim, who was also Ethiopian, was approached with a job offer by the couple. The couple requested her to be their domestic worker in Lesotho in return for a better wage. She accepted the offer and should be a cook, raise their toddler, and maintain their language and culture and Ethiopian ways. When she accepted the offer, the couple helped her get a passport and a tourist visa for Lesotho. When she got here, she was picked up by the second accused, who is the wife to the first accused. She was picked up by her and immediately she took her passport. The first month of her arrival, she was paid normally as promised, but the irregular thing was that the gate was always locked, except when the couple was entering or exiting the house. The victim could not leave the premises. As months passed, the victim was not paid. When she confronted her employer about it, she was told that her salary was being used to cover the passport fees and the traveling. And she was also paying for maintaining her and clothing her. A few months later, when she asked again, she was told that her salary was being sent to Ethiopia to her sister to educate her siblings. She was very desperate and she was vulnerable and unfamiliar with the culture and language, and her freedom was restricted, and she was physically and socially isolated. One day, another domestic worker who worked nearby noticed her that she would often sit outside and cry. And one day, this domestic worker tried to find out as to what was happening to her, but there was language barrier. She couldn't talk to her. So when she passed on another day, she saw a gardener working outside, a Mosotho gardener working outside. And then she approached that gardener like, "Gardener, can you just help me talk to the lady?" The gardener also had a language barrier with the victim, but they had their own way of communicating. So the gardener was like, "Okay, I'll find out what's going on," which he did, and he came back and conveyed the message to the domestic worker that, you know what, this person is being abused, she's just here, she's not being paid and stuff. The domestic worker then went to the police. The police didn't do anything. Days passed and police didn't do anything. The gardener and the domestic worker were like, "Okay, let me try and find the key, unlock the gate, and rescue her," which they did. The domestic worker took her to a place far from Maseru, where she called the police. The police came, took her, and put her in a shelter called Beautiful Dream Society, BDS. When she was there, that's when the trial began. When the trial began, she didn't have faith in the justice system because, remember, the police were called, but nothing was happening. And remember that in these kind of investigations, it's prosecution-led, and it means that it's guided by the prosecutor, and for it to be successful, it needs collaborative effort from the law enforcement and victim advocates. And the behavior of the police actually had negative impact on the victim. And therefore, she was not willing to cooperate that much. But then when the prosecutor came in, even though he was not involved in the investigation, as we know that it is best practice for both the prosecutor and the investigating officer to be present during interviews in order to demonstrate consistency and support, as well as to minimize the number of times a victim will need to be interviewed. The prosecutor re-interviewed the victim, and she was still not willing to cooperate, but the prosecutor was very patient with her. And the day of the trial came. When the day of the trial came, when she saw the accused, she clamped up, scared, she was scared, she couldn't say anything, and the case was postponed. When the case was postponed, when the day came again for her to testify, she testified with so much difficulty because she was not put in camera, even though they realized that she was traumatized by seeing the accused there. But then she gave her testimony with difficulty, and this was further complicated by the need for an interpreter, because their language was only spoken by a few people. Even an interpreter was not a professional interpreter, was just the person who knew the language. Unfortunately, the magistrate did not fully understand the crime of trafficking and exonerated the accused, citing that the couple was taking care of the victim and treating her in an acceptable manner, that is, providing her food, buying her clothes, and she looked healthy. The magistrate found that the accused were not guilty, as they were paying money back to her family in Ethiopia, and receipts were presented by the accused to show that they were indeed sending money to her home. This means that the court placed more emphasis on the good treatment she got from her employers, who gave her food and clothing, and salary being transferred to her family. It did not address whether she consented to such a transfer of funds. So, and we should remember that it's our role to ensure that these trafficking investigations or prosecution is victim-centered, and this was not the case in this Yusuf case. Post the trial, the victim was not repatriated, but rather was employed by BDS as a cook, and necessary documentation for a stay in the country was issued by the Minister of Home Affairs as per section, I can't remember the section, but this is provided for in our Anti-Trafficking Act of 2011. Thank you.
Thank you very much, Lesotho.
Okay, morning colleagues. One of the important things that I've noted in this case towards the protection or in pursuit of the protection of the victim. This victim, although the police did make a delay in response to find the victim, well, at the end of the day was put at the shelter, which is called the Beautiful Dreams, where she stayed there until the trial starts. Secondly, there was the time when the trial was proceeding, and the prosecutor found that due to the trauma of the victim, she cannot proceed, and he asked the court to adjourn so that he get the time to reassure the victim that he's on his side and he's going to help her. After that, he made sure she bring her back to the court
where there's nobody, and make sure he familiarizes the victim with the court and everything. Lastly, unfortunately, with respect to intermediaries, our CP&E only provide for protection on children, whereby the trial can be held in camera. Where the victim is the major, we don't have that protection. Thank you.
Thank you very much, Lesotho. Before I just give a few salient features, I just wanted to hear from Zambia. Give you just 2 more minutes, just to, if you have the information. Were there any measures taken to protect the victims in was it Muzara or Mutwale, or both? Mm-hmm.
I stated earlier on, during trial, the prosecutor applied to the court that the 5 children be taken by Ministry of Community Development and Social Welfare. That was done, and they were taken to a safe house.
Thank you very much. All right, thank you very much. Before we applaud you, I'm just going to point out a few features that I noted from our discussion. Victim protection, very central. Our cases are always going to turn on the evidence of the victim. That's the most important resource for a prosecutor in a trafficking in persons offense. So how we look after our victims is going to determine the level of evidence that we get. And so, you know, even in the last presentations, we heard about what prosecutors can do practically. There are those things that are provided for in the law, and I think South Africa has one of the most progressive laws in terms of protecting victims of crime. I'm sure the other countries that have similar legislation to South Africa probably enjoy the same protections. The whole aspect of appearing with an intermediary, all those things are protected in the law, which is a good practice for the rest of us to emulate. Like Lesotho, Malawi also has a protection only for children when it comes to, you know, witnesses testifying in court. So we can learn a lot from the best practices that South Africa has. And I also like the way they are, you know, the offenses have, the provisions in their procedure laws have been couched. You know, you're talking about those that have biological and mental incapacity. We don't tend to look at those as incapacities that by law should be protected when we're giving evidence. We have protections for mentally disabled persons, maybe in other offenses, but not when it comes to giving evidence. So those are very positive steps that we can emulate from South Africa. But we've also seen that protections are not only coming in as a result of law, they can come in as a result of practice. So what you do, what applications you make to the court, and how the court allows them. For most of us, we come from jurisdictions where cross-examination is seen as the right of the defense. And, you know, God help the judge who says, counsel, should you be asking that question? They will say, I have every right to ask any question in cross-examination, when half the time they're just being plain rude. So it's very important first to start with the prosecution. I was glad to hear that there was mention that it's a prosecutor's role to jump in and protect the victim. If you find the questioning rude, you really need to jump in and say, this is not on, because when the court interferes too much, you then start complaining that the court is prosecuting. So yes, the court does have that role. You know, I always respond. I will now put on my hat as a judge and say, if counsel says I have every right to ask any question, then you remind them that the court is in charge of the proceedings and the court must take charge of the courtroom. So, you know, that is not correct. The court must take charge, but obviously that must be balanced and you can't keep interfering all the time. That's why we need to work together with the prosecution as a team. Sentences, this is the first time I've heard that sentences are a way of protecting the victim. It's such an obvious thing, but we don't think of it in that way. For most of us, we have seen such lenient sentences. I keep asking at the end of the presentations, what was the sentence? You know, we keep hearing 5 years, 5 years, 5 years, 5 years. In the Kapinga case that was presented by Malawi, on appeal, the sentence of 12 years was actually reduced to 10 years. And this is a child who has disappeared and may never be found. So our sentencing should, we will rely on the prosecutors to raise to the bench that, look, sentencing is part of protection, and the court should begin to look at it in that way. I've also noted a good practice from Lesotho that both prosecutor and investigator are to be present at the interview. Now, this is brilliant in terms of, it's that one-stop approach when you are dealing with the victim, so that they don't have to keep repeating themselves to the prosecutor, then they repeat themselves to the clinical officer, they repeat themselves. Have a one-stop approach in the offenses so that the victim just has to say everything once. But unfortunately, our systems are such that by the time the prosecutor is told about the offense, it's many, many years after the victim was initially interviewed. So we need to find a way that we can foster some kind of good practice that everybody is at the same place right from the beginning. We've also seen from Lesotho that the acquittal in this Germay case, Joseph Germay, I won't say the surname, the acquittal was because the court found that there was good treatment of the victim. And we will see from the case digest that good treatment is actually a modus operandi. Sometimes bad treatment is a modus operandi. So I think we are seeing more and more that all this is just a result of not understanding trafficking in its entirety, and having the digest and sharing these experiences is a way that we can enrich each other. In that case, if the prosecution had argued that actually this is a modus operandi of trafficking, then the judicial officer would have been able to address that issue better. So thank you very much. I'm going to ask us all to give the panel a very big round of applause for their presentations. So that we catch up on time, I think we will have Rahel come in, and then after Rahel, then if there's a need for question and answer, we can deal with that then, so that we maintain the momentum. So I don't know if Rahel is ready, or are we going for the tea break?
Ready.
Sorry.
I'm ready, but I think you should have a tea break.
Yes, you're right, Rahel.
I think you should have a tea break.
Thank you, yes. I'm getting too excited. All right. Jeptam, yeah.
Thank you. Thank you very much, colleagues. Would it be possible to shorten the tea break from 30 minutes to, say, 20 minutes? Or even earlier? Even possible to have your tea and come and sit in? No? Yeah, then we can proceed. Fantastic. So whichever is easier for you, we'll see how full the room is. If you want to pick your tea and come back, and then we can just proceed trod on. Fantastic. Thank you. Let's do that. That this will be a key focus area when we take this regional digest to the countries and to your member states to really drill down on these issues so that we can ensure successful convictions and prosecutions. We have Rahel who's going to be leading us. Thank you so very much, Rahel, for joining us 2.5 days in a row. So over to you. The tech team, I think you can switch the screens to her. Thank you. Over to you, Rahel.
Hi. I want to describe to you 3 exonerations, not in the spirit of criticism, but rather in the spirit of trying to analyze how you can better prepare cases to deal with the weaknesses that the judges that cause the judges to exonerate. So I'm going to deal with 2 cases which you've already heard about, the Fakudza case of South Africa, the Joseph Germay Testagabar case from Lesotho, and a case from Eswatini, which is the Adigwa Dik case. Now, since you've already heard some of the facts of the Fakudza case from Karina, I'll just go over the skeleton so that you can find your place in the case. And I must say that Karina already gave us a certain path to follow here, because she suggested that perhaps a different charge would have yielded a conviction. In other words, charging the accused of trafficking for servitude might have yielded a conviction, whereas charging him with trafficking for sexual exploitation led to the exoneration. However, given that, I would like to raise certain questions that arise from this exoneration. Okay, so the skeleton of the facts is as follows. A 13-year-old girl is abandoned by her mother. She has been living with her mother and her stepfather and two siblings who are the children of her stepfather and her mother. Her stepfather previously sexually exploited her while still in Eswatini. They're all from Eswatini. At the age of 12, she reported this to her mother, but nothing was done. At the age of 13, her mother abandons her, and she has nowhere to go. Her stepfather has decided to take his two children to South Africa. She begs him to take her with him because she doesn't want to turn into a street child. At first, he refuses, but then he agrees, and he pays her bus fare to South Africa. They arrive in October of 2014. He does not abuse her for October, November, December, but during the beginning of 2015, he begins to sexually abuse her. As the court of first instance describes it, it's a horrendous situation because he abuses her wherever she is. And as the court of first instance says, he did not give her any space as a child. Whether she was lying down or sitting or doing chores, he would fondle her breasts, he would touch her, and he would have sexual intercourse with her. In addition, she was expected to take care of her two siblings and do all the chores of the house. So that she actually told the court that she viewed herself as his daughter, but also as his wife, which is very, very interesting. Now, the court of first instance convicted the accused of, I forgot to tell you that as a result of the sexual exploitation, the girl falls pregnant. And she's such an innocent girl that she doesn't know she's pregnant until a neighbor tells her. She thinks she's just gained weight.
Excuse me, Rahel. Sorry
Yes.
to interrupt you. We may have to stop for a little bit because they are not getting sound. The interpreters are not getting any sound. So far, nothing you've said has been interpreted. Could we ask you to hold on for 2 minutes while we resolve the issue? Tech support, please let us know when you've resolved the issue. And in the meantime, open to the floor. If anybody has any questions, any issues you want to raise, although I think interpretation is possible within the room, it's just it's a problem from speakers on Zoom. So if anybody had any questions, now is the time.
Bom dia.
Please go ahead, Amabelia.
Obrigada. Nós queríamos também...
Can you hear me? Yes.
Sim, queríamos também felicitar as apresentações que foram feitas na manhã de hoje. Nós tínhamos alguns comentários em relação ao caso Mabuza, que foi o caso que Moçambique teve a oportunidade de acompanhar muito de perto todas as fases da investigação e também acompanhamos, portanto, o julgamento que foi feito no Tribunal Regional de Graçcop. Os nossos comentários, na altura em que podemos estar muito próximos a estas vítimas. Constatamos que estas meninas sofreram traumas que naturalmente vão levar para a vida inteira, não só pela idade em que elas tinham na altura em que os factos ocorreram, mas também pelas agressões sexuais que sofreram. Uma das coisas que nós constatamos que durante o processo quando estas vítimas prestaram depoimento no julgamento, foi importante a presença de um familiar, no caso era mãe de duas destas vítimas, que foi possível trazermos de Moçambique para que esta mãe pudesse acompanhar e estivesse próximo às filhas e às outras vítimas e pudesse dar apoio e suporte moral às mesmas. Mas nós ficamos preocupados depois do processo terminar, preocupados porque, e isso tem sido um desafio, penso que todos nós, ao nível da região, enfrentamos, principalmente quando lidamos com casos de tráfico de pessoas, que é a questão relacionada com a compensação. No nosso ordenamento jurídico, é obrigação, por lei, está no nosso Código do Processo Penal, que o juiz, ao condenar um determinado autor de crime, deve também, na mesma decisão, arbitrar uma indemnização às vítimas. Indemnização essa pelos danos morais, pelos danos físicos e por aí em diante que as mesmas sofreram. No caso Mabuza, nós constatamos que estava envolvido um empresário sul-africano com recursos financeiros bastantes, e recursos esses que poderiam naturalmente ajudar com que fossem compensadas a estas vítimas. Não obstante que a compensação nunca vai apagar, nunca vai eliminar o mal que foi feito. Não só, mas também o sofrimento e o trauma que estas crianças terão que levar pela vida inteira. E o nosso desconforto é que passados todos estes anos, estas vítimas do caso Mabuza ainda não foram compensadas. Então, o nosso apelo era que nós começássemos, como região, a olhar para estas questões de compensação de forma muito mais, não sei como é que iria dizer, com muito mais, talvez com muito mais atenção, porque o próprio protocolo de Palermo prevê que é preciso que estas vítimas sejam compensadas. E, para além disso, temos visto que, na região da África, alguns países já têm, por causa destas questões de constrangimentos relacionados à compensação, nas leis de tráfico, criados fundos específicos para poder compensar as vítimas. E talvez alguns dos colegas aqui possam ter experiência, e nós, como estamos em processo de revisão da nossa lei de tráfico de pessoas, poderemos também ouvir algumas experiências a respeito disso. Mas era isto que nós queríamos partilhar. Muito obrigada.
Thank you very much, Mozambique. Well noted. I think that will help us in the way forward as we decide what to do next. Tech support tells us that we are now ready to hear from Rahel. So over to you, Rahel.
So can you hear me? I have an echo.
We can hear you without an echo.
No, but I don't hear myself without an echo. Okay, now I hear myself. Okay. So hello again. I'd like to bring before you 3 cases with exonerations, not in the spirit of criticism, but in the spirit of understanding which weaknesses. I again have an echo, I'm sorry. Which weaknesses led courts to exonerate so that prosecutors can better prepare their cases. Now, the truth is that 2 of the cases have already been presented to you, so I will just describe them in a skeleton kind of way. The 3 cases are the Fakudza case of South Africa, the Adigwa case of Eswatini, and the Yosef Germay Testagabar case from Lesotho. I think that the way was led by Karina when she, in analyzing the Fakudza case, said that perhaps had he been charged with trafficking for servitude, there might have been a conviction. So this is the kind of thing we want to analyze the case and see which questions arise and how prosecutors could better prepare the case for next time. Okay, I will start with the Fakudza case. Just to get you into the familiarity with the case, I'll go over a few of the salient facts. We're talking about a 13-year-old girl who lived with her stepfather, her mother, and her 2 step siblings. At one point, her mother abandoned her, and she was left with nowhere to go and the fear of being a street child. Now, I first wanted to comment that actually her stepfather had sexually abused her at the age of 12, and she had reported this to her mother, but nothing was done. So here this girl has been abandoned by her mother, and she has nowhere to go. So she applies to her stepfather, who wishes to travel to South Africa, and she asks to go with him in the hopes that he will not abuse her again. At first he refuses, but then he does pay her bus fare to South Africa. They arrive in October of 2014, and he doesn't abuse her for at least 2 months. But then in 2015, he begins to sexually molest her. And the court of first instance describes this in a very graphic way by saying that he left her no space as a child. He would molest her anywhere she was, whether she was lying down or sitting or wherever she was in the house. She had no space as a child. This is how the court of first instance described it. Now, she was also expected to do all the chores of the house and take care of her step siblings, so that she testified before the court that she felt like her stepfather's daughter, but she also felt like his wife, which is a chilling statement. In the end, she became pregnant, and she didn't even know she was pregnant. A neighbor told her that she seemed to be pregnant. She was an innocent child. She thought she gained weight. Only in the hospital did she report what had happened to her. They did a DNA test and discovered that the child was the stepfather's child. And he actually admitted that in court. So the court of first instance convicted the accused of trafficking and rape. And the accused did not testify and did not bring witnesses. What were the elements of the crime according to the court of first instance? The court of first instance focused on the act of harboring, because not only had the stepfather transported the girl to South Africa, he had also harbored her. So when he harbored her, the court of first instance found that it was clear that during the harboring, there had been an intent of sexual exploitation. The court of first instance applied the principle of the totality of the evidence. And I'd just like to read to you something that shows this. He said that the accused was already aware of the vulnerabilities of the complainant. As she was a young child, she had been abandoned by her mother. She had nowhere to go and nowhere to turn to. Her socioeconomic status was such she could not provide for herself, and she had no proper identification documents. Here I forgot to mention that they entered South Africa illegally, and the girl had no documents. Thereafter, the court of first instance says the accused started to abuse his power because he knew that the complainant was dependent on him for survival and basic needs. He treated her like a wife and mother and started exploiting the complainant, etc. Okay, so the inference that the court of first instance derived was that the accused harbored the complainant for sexual exploitation in the form of rape. Then the case was appealed to the High Court. The High Court upheld the conviction of rape, but it did not uphold the conviction of trafficking. Why? Well, first of all, the court focuses on the act of transport rather than harboring, and says that at the moment that the accused brought the child to South Africa, there is doubt as to if he had the intention of sexually abusing her. Moreover, although this is a case of child trafficking, which as we know does not require means, the court fastens on the means of abuse of a position of vulnerability, which according to South African law requires that there be no alternatives to the victim, and says that actually the victim did have alternatives. He mentions the following alternatives. She could have traced her mother. She could have applied to her mother's friend. She could have gone to her paternal uncle. She could have applied to the police. Given that, and given the fact that the accused didn't even want to take her, at first refused to take her, came to the conclusion that her vulnerability had not been abused. Now, as I went through this case and I read it a number of times to understand it, and as the representative from Zambia says, sometimes things are not clear. Up to this moment, the High Court decision is not entirely clear to me, but I do see the following things. One, the court focused on transport rather than harboring. What if it had focused on harboring? Would that not have led to a conviction? Because the basic reason why there's an exoneration is because the intent was not proven at the moment of transport. But was it not proven at the moment of harboring? Then I go on and I ask another question. Does the court think that the intent of sexual exploitation has to arise at the first moment of harboring? Is that the only interpretation that we can give to the trafficking offense? Then I ask myself another question. Why is the court fastening on the means of abuse of a position of vulnerability when we are dealing with trafficking of a child, which does not require means? Well, it is true that the court of first instance also mentioned this. It clearly stated that means are not necessary in a child trafficking. Now I ask myself another question. What about the circumstantial evidence, even at the moment of transport? What do we have here? We have a stepfather who sexually abused this child when she was 12. And he is well aware of her vulnerabilities, especially when she begs him to accompany her because her mother has abandoned her. He is in a position of strength and he knows it very well. He takes her without her mother's knowledge or consent. Begins to molest her a few bare months after they arrive in South Africa. This is circumstantial evidence, which perhaps could have I tried to see exactly how many months had elapsed. And the truth is that the case doesn't make it clear when he began to sexually molest her. So we don't know that, but soon after. Now, I also wondered to myself, what about the acute vulnerabilities of the complainant, of the victim? Were they given enough weight here? Could a 13-year or 14-year-old girl, she's 13 when he transported her, could a 13-year-old girl who was molested on numerous occasions, who was in a state of fear and pain, could she think in a very reasoned way, well, I have alternatives. Maybe I can trace my mother. Can a 13-year-old trace her mother? How can she trace her mother? Can she think clearly, oh, well, maybe I can go to my mother's friend? What's in it? Can she think clearly enough, or is she panicked? This is another question. I think that under the surface, there were two things here. One, the fact that the victim had initiated asking the accused to take her had an underlying effect on the court because it seemed like consent. And it seemed she initiated, he refused at first. Well, she consented. And another thing I think might have been under the surface of the court's decision was a thorny theoretical issue. When we think of harboring, the act of harboring, what is the difference between the act of harboring and what we call a standalone offense? If I harbor somebody for sexual exploitation, what's the difference between that and rape? If I harbor someone for forced labor, what's the difference between that and forced labor? Maybe under the surface that was at play. Now, Karina gave us one way of overcoming the weaknesses in the case, which was to charge the accused of trafficking for servitude. There, we probably, from the very moment when she arrived in South Africa, she was functioning as the mother of her siblings and she was doing the chores, okay? So maybe that would be one way of surmounting the weaknesses that the court found in this case. However, there are other ways too. For example, to address the underlying question of consent, is it true that that when a person, the victim, the alleged victim, initiates approaching the accused and asks him to take her, is that always a fact which negates trafficking? As you will see in the case digest, the answer is no. In 2 cases from South Africa, there were approaches by victims to the accused, and yet there were convictions. I refer to the Ogochukwu case, and I refer to the Obi Abba case. There are also international cases along those lines. An Israeli case, the Tibet case, where a woman approached a trafficker and asked to travel to Israel to engage in prostitution, and yet the accused was convicted. So that would be an issue which would be interesting for a prosecutor to raise, to anticipate how the court would see that, to anticipate this weakness, and raise that. I think that also another lesson from this case is that the prosecutor should clearly state to the court which acts constitute trafficking. In this case, the prosecution, I don't know exactly how they charged. I don't have the actual indictment, but it would have been good had they charged the act of transport and the act of harboring, because the act of harboring overcomes the problem of the intent. Because clearly when he was harboring her, he had the intent to sexually exploit her. Also, to prepare the circumstantial evidence which supports the intent, even at the moment of transport. So these are actually ways that the prosecution perhaps could have overcome the weaknesses of this case of Fakudza. Now I go on. Are there any questions, or maybe at the end? Okay. I go on to the Eswatini case of Adigwa Dik. This was a case concerning a Nigerian couple who was residing in Eswatini. They went to Nigeria and signed a contract with the parents of the alleged victim. And the contract said that the victim would come with them to Eswatini. She would help the wife with her business of selling wares. And in return, after a certain period of time, she would be enrolled in a tertiary educational institution. The girl comes with the couple to Nigeria, and she does work. But at one point, the relationship between the parties sours. And when that happens, the girl confronts the female accused and says she wants to be enrolled in the tertiary institution. She's not getting paid, but that's supposed to be her recompense. And the female accused tells her that there's no money for this and that she can't be permitted to return to Nigeria because she owes her money. Subsequently, the female accused detains the girl's passport and cell phone, conducts constant searches of her room, sometimes chases her out of the house. Moreover, the girl is not given adequate food or clothing, is assaulted several times and severely beaten. Several witnesses describe bruises on her face, scratches all over her body. She is not taken to any medical facility. The court exonerated the couple from trafficking in persons charges for two reasons. One, it entertained a reasonable doubt as to the question if the accused persons had intended to deceive the girl from the moment of recruitment and transport. This recalls the Fakudze case. The court is focusing on transport and recruitment, not on harboring. Also, it also says that this can't be trafficking because the girl agreed to do the work by contract. In other words, a consent issue. Now, if we analyze the two reasons for the exoneration, the following questions arise. First of all, is an agreement to do work, does it negate trafficking? In several cases of trafficking, we have contracts. But if it's an exploitative contract, does the fact that the victim agreed to it, does that mean that there's no trafficking? In order to assess this, I think that the principle of totality of the circumstances applies. Not only do we have the contract, which is a bare, simple contract, you will come with us, you'll help us in the business, we will enroll you, you will not receive any payment. So she agreed not to receive any payment, but did she agree to have her room searched? Did she agree to have her passport confiscated? Did she agree to have her cell phone confiscated, to be assaulted, to not to be fed? I don't know. It raises the question, why did the court just look at the contract and not at the totality of the circumstances here? Okay. Also, as Fiona noted, one moment. Yes. Right. There are cases in which traffickers use the initial consent of the victim as a method of control. One of these very interesting cases is a Canadian case by the name of Vurizar. In this case, a man trafficked a young girl of 18. At first, he started with good treatment and he took her by car places, and then he asked her to do exotic dancing, which is basically striptease, because he needed money, and she agreed to it. But at one point, she wanted to refuse. She said, I don't want to do this anymore. And he said, but you agreed. This is very powerful. We see many cases in which traffickers use this, but you agreed. And so they continue. So we could also see this as a method of control, okay? Not necessarily as a weakness in the case, but rather as a strength in the case. Okay, going onward here, we come to, again, the same question which arose in Fakudze. At the moment of transport and recruitment, it's not possible to prove without a doubt, without a reasonable doubt, that it had the intention of never enrolling her in the tertiary educational institution. But what about harboring? The question. This exoneration also gives food for thought, because here it's what Fiona said, that often gradual exploitation is the way things are done in trafficking. So that the lapse of time between the transport and recruitment and the exploitation actually can also be viewed as a method of control here, in addition to fakudza, which I forgot to mention. In other words, the lapse of time in fakudza and in adigwadi, from when the person arrives at the destination and the exploitation occurs, can actually be viewed as a method of control. So, what actually could the prosecution have done here? Perhaps what would have been important to actually show? Well, first of all, to stress that the act of harboring also occurred here. To stress before the court that it is often a method of control. The traffickers start out not exploiting the person and then gradually exploit her or him. To refer the court to cases where there were contracts and yet the court convicted. And this occurs in the Australian case of Wei Tang, which is a very interesting case, which has been mentioned previously. It was a case where a number of women from Thailand were signed on contracts to come to Australia to be prostitutes. In the contract, according to the contract, they were supposed to pay $40,000 to $45,000 and not receive any payment until they had reimbursed at these sums. These were arbitrary sums. They were enormous sums, and they required the women to work for free 6 days a week. They could earn money only on the 7th day. However, despite the fact that the women had agreed to this and signed these contracts, the court convicted. So this could have been something that the prosecution might have anticipated in order to prepare this case. I think that another thing that would have been important for the prosecution to do here is to stress the principle of the totality of the evidence. In other words, courts need to not only take a bare contract. What in practice happened after that contract? And this is what the court does in Wei Tang, by the way. What were the circumstances? And again, we've mentioned it several times in the course of this workshop, that the prosecutor needs to know and to explain the court every relevant circumstances from before the trafficking, during the trafficking, and after the trafficking. So the court understands who is the victim, what were the totality of the circumstances during the trafficking and after the trafficking. Yes. Okay, so those are things that could have been done. And as far as the, yes. Okay, that's a few things that could have been done. Now I want to go into, again, the Yosef Germe Testagaber, and the only reason I can actually pronounce this name is because when I worked in UNODC in Vienna, I worked with a man named Ashnafi from Ethiopia. It took me, I think, around 4 months to pronounce his first name. I still can't pronounce his last name, but this was easier. So as we heard from the representative from Lesotho, an Ethiopian couple takes into their house an Ethiopian lady who was apparently poor in order to cook and help them raise their child. They pay for her arrival in Lesotho, and the first month she receives the promised salary. However, the gate to the house is always locked. She cannot leave the premises except when the couple enters or exits the house. After the first month she is not paid, she confronts the employer. At first she's told that the cost of the ticket is being deducted from her salary and giving her food and clothing. A few months later, she's told that the money is being sent to her sister in Ethiopia in order that they educate her siblings. She receives no rest days, no vacation. She often sits out of the house and cries. She is rescued by a domestic worker who sees her plight. At first, this domestic worker complains to the police, who do nothing. Then she, with the help of the gardener, takes her to another place, and the case is opened. Now, why did the court exonerate the accused? For two reasons. One, because the couple took good care of the victim. They gave her food and clothing. The court also accepted the defense's version that they were paying the salary to her sibling in Ethiopia. So when we analyze these two reasons for exoneration, the first reason, does good treatment negate trafficking? This is a question. Well, first of all, again, we quote what Fiona said. Sometimes traffickers treat victims well at first in order to exploit them. Or sometimes, as in an Israeli case, where women in prostitution, trafficked for prostitution, were also taken to the beach and they were taken to parties, the Supreme Court justice said that was in order to get more work out of her. In other words, the good treatment was to get more work out of it, just as you treat an animal well when you want to use him. You feed him well so that he can work for you, okay? And the Case Digest does show us a number of cases where there was good treatment. One of these cases is the Koch case in Namibia, where actually the accused often shared food with the children. They offered them sweets. And also the Dragon case, where he was described as a loving man toward the children. Okay, so good treatment does not always negate trafficking. It could be a method of control. It could be something else. But in any case, it in itself does not negate trafficking. And this is something that the prosecution needs to impress on the court, needs to anticipate this weakness in the eyes of the court and turn it into a strength. Now, what about the second reason for exoneration? The defense brought receipts that they had transferred the money to the victim's sister. Does this negate trafficking? And here I again think that we might make this weakness into a strength. How? The couple never asked the victim if she agreed to transfer this money to her sister. She had no knowledge of this. She certainly didn't agree to it. So if they did it without her agreement, they were treating her like an object. This is a sign of ownership. Doing something with this woman's money, which she earned without her consent. That could be used as a sign of trafficking. So, in conclusion, I think that these three cases raise many questions, but we can use them. We can use them in order to understand what lies under the surface of the way courts view these cases. In Eswatini, we also have another case. The Men is another case. I find it hard to not Mendezebele case, where the same question of simultaneity of intent and act arose. So we see that this particular problem of tying the intent with the act arises in many cases. So we need to anticipate it. We need to anticipate it by either thinking of an alternative charge, as Karina suggested in the case of Pakudza, or by describing to the courts that there are several acts that it is possible to connect to the accused. Not only transport and recruitment, but also harboring. So if are there any questions or comments, I would be happy to answer.
Thank you very much, Rahel. It is 12:13. Yes, the participants would like to give you a big round of applause. So before we go any further. If there are any questions, we'll take some questions now. I just want to be guided by JEPTUM how long our question and answer session should be so that we have enough time for the next.
Thank you. I think we can keep it open because then we'd link the question and answer session on exonerations to the next, to the final session on way forward.
Time should the final session start? It's 12:13 now.
Can we aim for 12:40 at, at the latest so that we can go up until 1:30?
Okay. Brilliant. Thank you. Come to the front and moderate the question and answer session. Okay. Am I seeing any hands up? Oh, yes, we have a hand up from Zimbabwe, then Zambia.
Thank you very much. Good afternoon, colleagues. What I want to comment about is what my sister from Mozambique was talking about, the victim compensation issue. I think as a region, our attack on the perpetrators has taken a significant mileage. But it is the issue of victim compensation which I think is lagging behind. And if we say our approach is victim-centered, really what are we doing? Do we have examples as to what was given to which victims and what was the exploitation behind the conviction? And if any of our colleagues here are able to tell us that in a particular case, a victim was awarded compensation by the criminal trial court, and also has it been, the issue been dealt with on appeal, the main appeal by the perpetrator, and how has that been viewed in our studies? I am a bit worried because we have covered a lot of time dealing with this issue of TIP, and in as much as we know that victims have been comforted throughout the trials and post-trial counselings have been done, but in terms of compensation as required by our laws, has that been done practically? And if not, what shall we do together to ensure that that is enforced? Thank you.
Very much, Zimbabwe. Any more? I know it's Zambia next, sorry.
Yeah, maybe just looking for a bit of guidance from order heads. So, maybe I didn't get the facts correct, but in a situation where we have a contract, and this happens a lot in our communities, where people go to the village and say, okay, I have a baby, for instance, and I want this 12, 13, 14-year-old girl to come over help me take care of the baby, and in return, I'll take her to school. And so the relationship is fine until it sours. So when it sours, are we then at liberty to then turn it into a trafficking case after it sours? Regardless of, yeah, obviously, the assaults start after the relationship sours. So can we say this person was trafficked? Or are we just going to call it assault? I would like that clarified, because these are situations that happen. I think even the Esther Perry case or something like that? No? Anyway, but we see this a lot. So is it trafficking even after the fact?
Thank you very much. Are there any more questions? So we've taken note of the questions. I think primarily if we could have questions for Rahel, and then the next session after this, we're going to be talking about these issues that we will be dealing with as follow-up, where we have gaps and issues like that. But don't feel constrained. If you want to bring up gaps now, that's fine. It's just that Rahel is here to answer our questions. If anybody has any questions for Rahel.
That was the question for me.
Yes, the second one was, but the first one was on sharing practices and working together on compensation. So,
okay.
Yeah. Any more questions for Rahel? Okay, Rahel, go ahead and answer the questions that have come up. If you feel you want to also respond to Zimbabwe about the issues they're raising on compensation, please go ahead.
Okay, as far as what the Zambian representative raised, it really depends on the circumstances. Okay, I think that in the case that I presented, the Eswatini case, it depends. You must always connect the intent with the act, okay? So it is very possible that at the moment of making the contract, there was no intent to exploit. The person really wanted to enroll this girl in a tertiary educational institution, but she didn't have enough money to do it, okay? In the end, she didn't have enough money to do it. So that would be fine. However, not only did she recruit the girl, not only did she transport her, but she also harbored the girl. And at some point in the harboring, we can view it as an intent to exploit by forced labor. The girl was not getting any payment. The girl was being starved. The girl was being assaulted. The girl had her passport taken, her cell phone taken. She was bruised. So at some point during the harboring, this intent to exploit her crystallized her. She was also threatened that she owed money and therefore she could not return to Nigeria. These are all red alerts as regards trafficking, okay? This is not a simple case, I agree with you. Do we think, is it the case that the person, the accused, needs to crystallize the intent at the first moment of harboring? Or is it sufficient that they crystallize the intent at some point in the harboring? This is a question which needs to be addressed. The court of first instance in the Fakudza case clearly thought that yes, the harboring, if the intent crystallizes during the harboring, that's enough. Now, I don't say that this is not problematic. Why is it problematic? Because as I mentioned, when I was analyzing the Fakudza test, the act of harboring, how do we differentiate between harboring for forced labor and forced labor? Okay, which is the end offense. And maybe that's something that you could consider as prosecutors, that in these kind of cases, maybe what you need to charge is forced labor, just to be sure, okay? Because in forced labor, you don't have that problem of relating the intent to the act. So that's an alternative for you to accuse of forced labor. But what I do want to stress is a contract in itself is not enough. That's more of the approach of a checklist. Oh, there's a contract, so all is well. No, we need an in-depth analysis of the case. We need to see the whole picture. We need to assess the totality of the evidence. How was the victim treated during the harboring? So I raised maybe more questions than I gave answers, but that's my answer.
Thank you very much, Rahel. Are there any more questions from the floor? Oh, I've seen two hands up, South Africa and DRC. So in that order, South Africa, please go ahead.
Yes, I actually also just want to comment on what Rahel said. In terms of harboring the Fakutsi case, I think that was really what the judge had ruled, is that because of the willingness of the victim to be with the accused, and Rahel had very correctly pointed out, if you look at the fact that the child was 13 years old, she had no choice but to be with the accused. So I do agree that the judge found the judge ruling in that respect was, in my opinion, mistaken. But I think that was why he was acquitted on trafficking. The judge thought that unlawfulness or the unlawfulness was negated by the mere fact that the child was there willingly. So it wouldn't have really made a difference in terms of harboring or transporting, because the court found that it wasn't unlawful because the child consented or was there willingly.
Thank you very much, South Africa. DRC?
Merci bien pour la parole. Je crois que je vais continuer dans la même lancée que un collègue de l'Afrique du Sud, parce que c'est par rapport au premier cas qu'on a développé pour l'enfant de 13 ans. On a dit que, Raël a dit clairement que dans la logique, on ne pouvait pas penser que cet enfant de 13 ans pouvait avoir l'alternative d'un choix, d'autant plus qu'à 13 ans, on est traumatisé, et à 13 ans, en étant mineur, chez nous au Congo, il y a déjà vice de consentement. Dès qu'on a moins de 18 ans, même lorsqu'on arrive à dire un oui ou un non, à avoir la capacité de décider, on estime que cette décision est déjà biaisée de part de l'âge de la personne. Alors, ma curiosité de savoir, est-ce que le ministère public, dans cette affaire, est allé en appel contre cette décision qui semble être illégale, qui semble ne pas rencontrer le droit? Est-ce que le ministère public est allé en appel pour qu'on puisse réformer une telle décision qui biaise même le droit de la victime?
Any more questions before Rahel gives us some answers? Okay, Rahel.
I didn't exactly understand the last questioner's question. Fiona, could you clarify it to me?
Maybe I can ask DRC to articulate it again so that we don't misquote you. DRC, the last bit, your question, what exactly was it, so that Rahel knows what she's responding to? There's no translation, apparently.
Alors, je disais ceci. Eu égard au premier cas, qui traitait de la vulnérabilité, de l'abus de vulnérabilité de cet enfant de 13 ans. Raël nous a clairement dit que cet enfant, dans son raisonnement, c'est que cet enfant ne pouvait pas avoir d'alternative, d'autant plus qu'à son âge, elle était traumatisée et ne pouvait pas recourir à une aide quelconque. Et lorsque nous revenons à notre loi portant protection de l'enfant, chez nous, une personne qui a moins de 18 ans n'a pas un consentement éclairé à donner par rapport à un choix. Dès lors que on a moins de 18 ans, le consentement est déjà biaisé de par l'âge, parce que la loi protège l'enfant de moins de 18 ans à cause de son statut de mineur. Alors, ma curiosité était de savoir, est-ce que face à ces jugements, à ce raisonnement qui était illégal, à ce raisonnement qui biaise le droit de la victime, est-ce que le parquet ou le procureur sud-africain, je crois que c'est un cas sud-africain, est allé en appel contre cette décision?
Okay, thank you very much. It's going to be DRC again next. But I think, Rahel, I think the essence is, why didn't the prosecutors appeal on the basis that a 13-year-old couldn't have capacity to consent?
Well,
so we'll just have the other question from DRC before you respond. DRC, you had another question? Yes, go ahead.
Merci pour la parole. Ce n'est vraiment pas une question adressée à Madame Raël, mais c'est une question adressée à nous tous. C'est une réflexion par rapport au recueil des jurisprudences que nous avons ici. J'ai remarqué dans la plupart des exposés que lorsqu'on parle de l'exploitation sexuelle, le ministère public ou les juges tient compte de beaucoup d'éléments. Il y a un faisceau d'éléments. Soit par habitude, la victime est violée, soit elle est laissée à l'abandon de son bourreau. Et lorsqu'on parle du travail forcé également, je vois qu'il y a un faisceau d'éléments. Est-ce qu'il n'y a pas crainte? Parce qu'il y a un principe latin qu'on utilise évidemment dans les procès, in dubio pro reo, c'est-à-dire le doute profite toujours à l'accusé. Avec tous ces faisceaux de moyens qu'on cherche à réunir à charge d'un auteur de trafic, est-ce que, lorsqu'on a affaire à une défense forte, est-ce que ce principe ne risque pas de renverser l'action du ministère public ou bien ne risque pas de jeter disons pas un doute, mais de froisser un peu la motivation du juge pour retenir en fait la traite des personnes? Est-ce qu'il n'y a pas crainte qu'en cherchant à mettre beaucoup d'éléments pour la définition de la traite des personnes, qu'on en arrive au doute? C'est une réflexion que je voudrais lancer à nous tous, parce qu'en suivant tout le monde, nous tous y compris, je me suis rendu compte que pour la traite, pour retenir le trafic ou la traite des personnes, on tient compte de beaucoup d'éléments, surtout en matière d'exploitation sexuelle. Merci.
Okay. Thank you very much. So, one more question from Eswatini, and then Rahel can answer.
Thank you, my lady. I would like to know on the South African case as to, we hear that the 13-year-old eventually got pregnant, as to what happened to the child and the victim, because here is the perpetrator, now he's convicted of the rape. What happens to those children that then get pregnant after being sexually exploited?
Rahel, please go ahead.
Okay, so hello. About the question about a minor's consent. So I think that in the South African case, the Court of First Instance was very well aware of the victim's vulnerabilities. Not only was she a minor, she was a girl who had been sexually molested when she was 12 years old by this stepfather. Think what that does to your trust. She had nowhere to go. She had no alternatives. Court of First Instance was clearly well aware of vulnerabilities, including of the fact that she was a minor, for goodness sake. I think, I only suppose, because I don't have the prosecution heads of argument to the High Court. I suspect that the High Court's judgment might have been a surprise to the prosecution. It certainly was a disappointment to me because I had read the Court of First Instance and I thought it was such a good case, such a good judgment. So the High Court was the instance which stressed this child's alternatives. And yes, I agree with you completely, a person from the DRC, that to expect a 13-year-old child to exercise cool and calm judgment is unrealistic. But what this does show us is that under the surface, in every case, there will arise claims of consent. And even if your legislation clearly states that consent is irrelevant, as prosecutors, you will need to prepare your case so as to explain to the court why this was not genuine consent. The power gaps, the acute vulnerabilities, the nowhere to go. These are the things that will need to be prepared, even if you have a legislative statement that consent is not relevant, and even if in your legal system, the consent of a child is meaningless. It'll always arise under the surface. As far as the question from the representative from Eswatini, it's quite interesting. I can't know everything about what happened to this girl. And actually, I asked Jepton if we could not do some sort of project to track down some of the victims who testified in cases which appear in the case digest. For example, I personally would really love to meet Els from the Easy case of South Africa. I would love to meet her. I want to meet the victim in the Mabu case. Okay? What happened to these people afterwards? But what I do know about the girl from Fakudza is she was an exceptional girl. And I think that the doctor testified in that case, if I'm not mistaken, that she was mature beyond her years and taking her motherhood seriously, although, of course, she was traumatized. So I don't know what help was given her. That I don't know. But I do know that she was an exceptional girl and that she was trying her best to be a good mother.
Thank you very much, Rahel. I just also wanted to put my voice behind this question from Eswatini. You know, what happened to the victims afterwards? Rahel's suggestion about following up victims is very important in terms of, you know, learning from the past. But I think one other important issue we shouldn't lose track of is that we are still going forward. And once you start acknowledging and realizing that these girls are so traumatized, they should have been assisted beyond the trial, that's a very important lesson that we've learned. It means we're moving in the right direction. It means from, you know, whatever case you do, you don't look at it as having the time frame of only the prosecution that you are conducting. There is a continuum. You know, afterwards, there are going to be other issues that may have to be taken care of. I noted that in the Yosef Germay case, the victim was given status and remained in Lesotho, which is consistent with the protocol that, you know, we're supposed to take care of victims. And that's a good thing, especially if they can't return home, because most countries are so keen to repatriate people back home without realizing what's going to happen to them afterwards. So here are some of the good practices that we could enforce. And I also just thought very quickly that, you know, what happened to this victim in terms of the child that she gave birth to. I remember I am no longer a judge working in a criminal division, but I was at some point, and I remember in an appeal case, somebody who had raped a minor and had impregnated her, his lawyer argued that his sentence should be reduced because he's now a father and he should be allowed to go home and take care of the child. He said it was in the best interest of the child that he has a lenient sentence so that he can take care of the child. Yes, I almost fell off my seat. Thank goodness for our stoic training. So these are issues that do come up, you know. What does it mean to take care of the victim and to take care of the victim's child? There is a wrong way of thinking of it, but there is also a right way. So perhaps the way forward from here is to start to come together with a community of best practices for how we can take care of victims afterwards. And the last thing I will add is that we have in Malawi a what is it? Marriage, Divorce and Family Relations Act that allows a pregnant woman to claim from a man who's impregnated her to claim maintenance. And one of my colleagues has been advocating very strongly that in defilement cases of statutory, I don't like the word defilement, I prefer to use the word rape because defilement is such a belittling and objectifying word. So in these rape cases where the victim is pregnant, we can even use laws such as those laws of civil procedure to follow up and get maintenance, assuming the defendant is not a man of straw. And considering, as was said on the first day, that many times once you convict somebody, his earning capacity is reduced. So how do you enforce this? So there are a lot of issues, but it's a step in the right direction that we're thinking about them. So thank you very much. I think that concludes this session. We can move on to the next session on the way forward. Let me just... I'll invite Jeptum to come and sit with me in the front. We've come to a point where we are now going to look at the key issues that have arisen in the past few days. I didn't get around to everybody, but I tried as much as I can to have a word with a number of countries just to find out how we can take this forward, what your thoughts and feelings were. And, you know, there seems to be a lot of consensus on certain things about how we're going to move forward. So I'll just give us a very brief recap of some of the salient features that we've seen, some of the issues that we really need to grapple with. And today we keep hearing compensation. So we know that whatever it is we move away from now, we need to sit down and discuss how is it that we're going to make sure that our victims are protected? Does it have to be through amending legislation? Can it be done through practice? For those of us that have funds, victim funds, are these funds working in practice? Are people aware of them? Do they actually reach the intended beneficiaries? So moving on, the salient issues that arose on the first day, we looked at vulnerability of the trafficker as well as the victim of trafficking. I think it's important to note that sometimes victims end up being traffickers. This cycle of abuse, you know, abused people abuse other people. You'll find many cases in which the trafficker is a former victim. So if we don't deal with issues of victims, they end up being traffickers. But also, I've forgotten what I was about to say. But also, traffickers themselves victims themselves don't easily identify. And you may find somebody who is being prosecuted as a trafficker when they are actually a victim. You know, traffickers will sometimes coerce their victims to commit crimes. And so since in many cases we are finding that it's not the actual trafficker that we catch, it's always the middleman. And it's very likely that many of the people we see in our courtrooms as the traffickers could also be victims. So there's a very important issue about identifying victims. I wonder how we could program around being alive to the issues so that we know when we have a victim or when we have a trafficker. The issue of compensation I've already talked about. We need to be sharing best practices. As Mozambique is saying, they have an opportunity to review their law, and if they found best practices, that could help them in reviewing their laws. If anybody else feels that reviewing their law is something that they could be supported in, this is something we can all share. Profile traffickers, being persons abusing positions of trust. We've dealt with that quite a lot, either uncles, important guardians, pastors, witch doctors, and the like. Strong multicultural support services. We've seen in the Jonas case how IOM played a very big role in repatriating the victims, and we have been talking consistently about looking after the victim beyond the trial. What other partners are available to us? How do we reach out to them? Because sometimes it's really, you find yourself as an island, you're doing this case and you don't have the embassy of the victim in your country, or you've tried to reach out and nobody's, linguistic or problems, you don't even have interpreters. How do we deal with this issue? And on the issue of interpreters, I'll share a story that we heard during one of the trainings, that the interpreter was supplied in a particular case by the accused person. And this interpreter was not interpreting what the victim was saying. And it was only after the transcript of the trial was sent to South Africa that they were then able to send, what was actually being said. So every time the victim spoke, totally different things were being told to the court and vice versa. So, assisting each other in helping the victim to get the right resources, embassy staff, interpreters, that's also an issue that could be considered. Sexual and reproductive health rights implications. We see that in the Jonas case, somebody was taken to hospital to be, and without their permission. And this is happening in a number of cases. You even get yellow fever certificates and the like. We have the cross-cultural issues of African culture, these charms, albino killings, that are common to so many of us. I was very interested to hear yesterday when the colleagues from Zambia said in Zambia they say albinos don't die, they just disappear. And we say the exact same thing in Malawi. So we are facing the same, and I had a conversation with somebody a few days ago who said he grew up believing that albinos and he thought that was a real thing. So knowing our similar backgrounds, how can we work together? Because usually once somebody crosses the border, that's it. How do we enhance cross-border cooperation? There have been a lot of issues about trauma and expert witnesses. For many of us, these experts are not within our reach. South Africa is amazing. They can find an expert on anything. But I wonder, Seychelles, Lesotho, Malawi, how easy is it for us to find these experts, and what can be done? Can we have a database or a pool of experts that can be used in Southern Africa to help in this sort of cases? Use of substance abuse in recruiting, men as vulnerable victims in labor, all these are knowledge areas. They indicate that either the prosecutors, judicial officers, or even social workers are not aware of certain issues. And what has come out from my discussion with the very many countries the few countries that I spoke to, is that there's need for training. So whatever happens, we need training. And what is being proposed is multi-sectoral training. So you have the prosecutors, the police, the legal profession, everybody in the same, or receiving the same type of training, so that we are all on the same page. Moving on to the second day, what came out as salient features. There were specific issues on trafficking in labor, and I'll put that down again as knowledge areas. We need to be more trained. I think one thing that Rahel stressed is that most of the times when the court sees trafficking and it's linked to labor, we always assume, these are just labor issues and they don't go beyond that they are not viewed as trafficking, and also this normalization of treating immigrants as second-class citizens, that people don't even report when they see, you know, factory workers or domestic workers being abused if they're foreign. That's also a very big knowledge area that, that can be looked into. So again, we had issues of consent, victim reaction, which again I would describe as knowledge areas. Mutual legal assistance came up again, and the whole issue of proving exploitation, prevalence of sexual exploitation. And today we saw a lot about consent and underage children. And again, all these issues, as I said, are all about knowledge. They are all knowledge areas. So just again, going through the issues that I've been discussing with the various delegates, the issue of interpreters was also raised with the small islands. You know, they mentioned that there are so many different dialects. So even within a country, you can have so many different dialects that interpretation can be a challenge. Lesotho shared an interesting good practice in that they say a lot of work has been done with IOM and other partners in training the prosecution, the police, so that right now, you know, the intake phase of the crime is being so well handled, and there's a little bit of a gap with the judiciary. So we could also learn from them, from their trainings, how the intake stages can be improved so that we are all at the same, level. A number of countries also mentioned the advantage of having a training manual that is going to be used by the different stakeholders in the criminal justice system so that there's consistency of approach. One delegate mentioned, you know, this communal sharing to say, could we be facilitated to have a WhatsApp group so that we can easily just share practices? WhatsApp groups have become so common. I was laughing the other day, somebody said, you know, when the moment you step into a taxi with people in that taxi, by the time you're getting off, you formed a WhatsApp group. I wouldn't want this regional prosecution meeting to fall behind, so JEPTAM, help us. I'm just trying to see if I've missed. Yes, and I believe one comment that was made was, can we urgently bring this regional case digest to judges? So, JEPTAM, over to you. This is the recap and some of the issues that have been raised by the participants.
Thank you. Thank you so very much, Lady Justice Mwale, and really thank you very much, participants. I also want to just add on what Lady Justice Mwale has said on key issues that we picked up on before we go on to the next steps. It was evident from the cases you spoke about this week and the cases in the digest and the cases that we've come across that a significant number of cases in the South African region involve children and minors. You know, anyone under the age of 18, particularly persons, children between the age of 10 years and 16, 17 years, which is quite, it's quite disheartening because really, it really shows, over and above showing how the moral fabric has really degenerated, it really shows that we really need to put extra effort because children need extra significant protection so that they can really have a chance to have a good, normal life, a successful life, and really lead us into the future. And it also, this meeting has also brought to the fore the fact that the challenges that come with having children as witnesses, as victims, the very good example that was not, could not have been recorded in the court transcripts by Namibia on how the first trial case, the judge was not very aware about the substance matter, and the second time he was more amiable, even giving the child a chance to sleep so that they could gather their thoughts or rest and come back for a similar session. I think this really shows how we really need to put extra work for our judiciary and for us as prosecutors so that we can really be able to have a court system and a court judicial process that is friendly to the children who are victims of trafficking, who have already undergone a lot of trauma, so that they can A, aid the prosecutorial process, and B, also just ensure justice is served for them and their families. That leads me to again, the other aspect that has come to the fore significantly here is that a number of cases in the South African region, again, end up being cases of sexual exploitation and rape. Most of the cases, at least 70% of what we've heard of this week, if not, has ultimately led in rape cases, rape charges. And I'll not use the word defilement, as I hold the same sentiments as Justice Mwale. So this is very serious because the trauma that comes from rape and defilement is really long-lasting. It's very difficult. And it's very unfortunate that a case that is not just rape, is trafficking and defilement, ends up being adjudicated as a simple rape case or a rape charge. And you know, it really again goes back to the fact that we need to buttress our effort and our roles, your very distinguished role as prosecutors, to be enabled to, the perpetrators get the right, really, punishment that they deserve, that is meted out to them to fit the crime that they perpetrated. Third, I just want to say that there's which we all know, there's a distinct link between trafficking in persons and other transnational organized crime charges. Those are mentioned by Karina this morning on the issue of drug trafficking and it being servitude because they are used as mules, which is, you know, they end up being charged as drug traffickers, but if you take a deeper look, they're really victims of trafficking who've been trafficked to undertake this action. So the nexus of this transnational organized crime with trafficking in person, with TOC issues, drug trafficking, wildlife product trafficking, and other crimes, I think is very important. And it's good for us to know that there's an opportunity for us to work with international systems available, for instance, Interpol, to be able to just put a whole sort of network of interventions together to be able to stop the networks at the head, so that you, in my culture, you say that you cannot kill a snake by hitting the tail. You have to hit the head so that it dies, so that we hit the main people who are benefiting financially from these crimes, following the money, following the evidence to the head, so that we get the head and stop this really scourge in South Africa. So I do not wish to take a long time. I just really want to hear from you how you see, particularly from your member states, us advancing this forward. I really think it was very useful. This regional case digest, as has been put together by Rahel and all of you actually, is really important. It provides a quick reference guide for even prosecutors when you want to do research and see case law quickly. It's really there. And I think your colleagues, our colleagues in the countries can really benefit. How can you advise that we move this forward to each country, or to bilaterally or regionally? What do you see as the important areas for your country? For instance, for one country, it might be labor exploitation. Another one, it might be focused on sexual crimes. Others might, different elements of trafficking in persons per country. So we're very happy to hear from you. For UNODC, we really avail ourselves to partner with you, to work with you on whatever you request from us that can really give you the tools and the capacity to work on trafficking in person cases and issues with you. Even items that look very, I wouldn't say menial as a request, for instance, translation, as was put together for Seychelles. If you need support for translation or support to bring translators in, or expert witnesses, as was brought about by Karina in the South African case, we're happy to do that. We've done that before. I was informed well that I was not aware my predecessor has done that for Namibia and others. So really, over and above the big actions, which is the training and others, we're happy to work with you and walk with you in this road. So I don't want to speak more. I want to open the floor, if Lady Justice Mwale allows, to you to tell us how you'd like it to be moved. This year, for instance, we really want to scale up our interventions in terms of training of prosecutors and judges, if they allow, because I appreciate how difficult it might be to penetrate that. But judges, but because you're here as prosecutors, we want to come to your colleagues first. And maybe the judges can, if they have a lot of prosecutors coming to them with the same different angles of the same issues, then maybe they might be more open to interventions. But then I don't want to speak more. I open the floor to you for your thoughts, comments, and guidance. Thank you very much.
Thank you very much, Jeptum. Zambia already has a hand up, as does Seychelles after them.
Sure. I would just say maybe I would request for maybe just knowledge of, there's a situation that's been brewing. I think, I don't know whether Tanzania and Malawi are aware, but I'm sure they are. From the end of 2020, this is 2022, right? The end of 2020, we've seen a spate of cases in Eastern Province, where I come from, where there's been mass trafficking of people. I know we've been talking about these 12 children, 5 children, but especially Ethiopians. I can only assume it's because of the war, but obviously I'm not qualified to make that statement. But literally, we would get a situation where 60, 70, 80 people in a truck. And those are just the people we've managed to get. And so on. So even after we find these people, just imagine how these poor people have to, until we finish the case, then that's when we think about deporting them, and how much it would cost to deport them, and translations, even the food that they eat. They eat, I think, a different kind of food. The constitution maybe won't be able to handle what we call Nshima. So in as much as we are here talking about prosecuting, I think there's a human side to it. And this is something that is happening. And when you ask them, they're saying, oh, well, we're trying to get South Africa. The consent issue also comes up. But it's huge. We try, but just imagine 80 people packed into a container. It's you know? Yeah, so just since we're here in the region, there's that going on. So just putting it out there, basically.
Much Zambia, Seychelles.
Yes, good morning. As you all know, we are a very small island nation, quite far away from the mainland. And most of the crimes and offenses that my colleagues and I have heard today, some of them we only experience, I would say mostly on television. Because we don't share a physical border, we tend not to experience these types of crimes, like the ones for trafficking for organs. This is something very strange. We've never experienced something like this. So what I'm trying to say is that for us as prosecutors, if this is strange for us, it will be the same for our judges and magistrates. So sometimes, because of this, as it has been pointed out before, that judges, we as prosecutors, we respect the independence of the courts. We will never want to bully or influence the jurisdiction and the powers of the courts. But UNODC as a friendly institution may somehow, some way, have judges and magistrates in one room and experience the same type of experience that us prosecutors today, in these 3 days, have experienced. So this will open their minds, as it, I'm sure, did for us, because sometimes we may experience one or two type of crimes, and the others are maybe not prevailing in your country. And I'm sure it's the same for our judges and other legal practitioners. Thank you.
Thank you very much, Seychelles. We have a hand from Eswatini, after which South Africa, and then Namibia.
Thank you so much, Judge Fiona. Mine is to appreciate the work done towards compiling the digest. I think it is a very useful document for everyone who's in the legal field, and also to suggest that really we do need trainings. This workshop here has been an eye-opener. The sharing of experiences and ideas has really helped a lot. There are issues when you are a prosecutor which you tend to disregard, but now we know what to look at, and with the help of the digest, we will be guided on how to tackle our issues in court. I really feel it is important to have prosecutors and police officers, especially the investigating officers, under one roof in one training. And I think the program which we followed here this week, it has been, if it can be followed in the trainings in our countries, it can be very efficient. Yes, and I also suggest that you guys find a way on how you can get the judicial officers also sensitized. I will call it sensitization, not training, on these issues, because it will not benefit us as prosecutors and investigators having the knowledge, and we will be going to court to present our cases to them, and we will expect them to know what we are talking about. It will not be easy for us, and we will not see the fruits that we want to see at the end of the day. Thank you.
Thank you. First, I would really like to thank UNOTC for the work that they've been doing in trying to capacitate us as a region. We've come a long way. At least I'm speaking for Namibia. We've really come a long way. Our eyes are open now. Okay, we are not experts, not by a long shot, but we are now at a stage where our detection rate and investigation and prosecution rate has improved tremendously. I also would like to express my appreciation for the digest. A lot of work was put into that digest. I marvel at the work that Rahel has put in there. I don't know how much time she spent reading judgments from all the countries of the region to come up with the document that she has come up with. It will be a very valuable resource for all of us. And also thank you for bringing us occasionally as prosecutors around the region, because we do need to sit around the table and share ideas. We really appreciate that. For Namibia, I believe much as there has been an improvement, we still do need trainings, because in my view, you can never overtrain. Sometimes you train and then the person that you have trained goes back into the field, let's say it's a prosecutor or an investigator, and while working, they experience certain challenges, and they would actually benefit from a further training to clarify the issues that they might have met practically. We've also noticed a new phenomenon, if I can call it that, which we were not aware of. I can't say it was not there, but we're not aware of it. And that relates to albinos. We have a case that just appeared in court yesterday involving persons who were supposedly sent by people from India to collect albino hair, and that is supposed to enrich those who are providing the hair to the Indians and the Indians also. That is a new area for us, but I noticed that colleagues from around the region, some of them have already had experiences regarding albinos, and we would really appreciate a situation where we can, in the trainings that we have, focus also on the issue regarding albinos. Thank you.
Thank you very much, Namibia, South Africa.
Yeah, I think Eswatini had really covered me in terms of I would like to see this as a country, the same setup for the countries in terms of what the value was for me, for instance.
Mozambique. Thank you, South Africa.
Muito obrigada. Em primeiro lugar, nós gostaríamos de aproveitar esta oportunidade para agradecer ao Escritório das Nações Unidas contra a Droga e o Crime por nos ter proporcionado esta oportunidade de estar aqui a partilhar experiências com os países da região austral. Tudo aquilo que nós podemos aqui ouvir desde o primeiro dia deste workshop fez-nos criar a convicção de que, efetivamente, temos que todos lutar contra o crime de tráfico de pessoas. E muitas das questões que foram aqui debatidas e analisadas constatamos que são questões que nós, como procuradores, como juízes, no nosso dia de trabalho, enfrentamos. Então, notamos que existe uma identidade em termos daquilo que está-se a passar ao nível da região austral. Nós pensamos que é importante o apoio que a UNDOC pode prestar, principalmente na organização de capacitações quer para os procuradores, mas também para os juízes, e por que não, e na sequência daquilo que foi dito pelo meu colega das Seychelles, se isto fosse até organizado a nível regional. Outro aspecto que nós queremos também deixar aqui é que é importante o reforço da cooperação bilateral entre os países, principalmente aqueles países em que tem fronteira. No caso de Moçambique, Moçambique tem fronteira com a África do Sul, tem fronteira com Eswatini, com Malawi, com a Tanzânia, com a Zâmbia, Zimbábue. E nós temos estado a tentar, com cada um destes países, reforçar a cooperação bilateral, por forma a que todas as situações que ocorram em que envolvam cidadãos moçambicanos, situações de tráfico naqueles países, nós possamos ter conhecimento em tempo recorde e possamos, igualmente, prestar toda a assistência que for necessária. Temos feito isso muito com a África do Sul, também com a Eswatini fizemos, num caso que tivemos, que envolveu uma vítima moçambicana. Tivemos a mesma experiência com a Tanzânia, há 2 anos atrás. Então, nós queremos dar a nossa disponibilidade, que estamos prontos para colaborar com todos aqui que estão aqui presentes para reforçar aquilo que é o nosso trabalho na prevenção e combate ao tráfico de pessoas. E uma vez mais, também obrigada a UNDOC e obrigada a Rael por este compêndio que vai ser muito útil no nosso dia de trabalho. Obrigada.
Thank you very much, Mozambique. Tanzania.
Thank you for giving me this opportunity. First of all, I would like to thank you, NODC, for the work done, and all members who participated in sharing experience that has added value to us. Also, I've realized that in Tanzania there have been a problem in drawing demarcation between the offense of human trafficking and other related offenses. For example, as mentioned by Namibia, on the issue of albinos, we have been charging on different offenses like assault or something else, but we actually admit that to have neglected the offense of human trafficking. So this has been an added value to us. We're going to work on it and be clear on drawing a clear demarcation on the offenses. On the issue of training, we think it's very important for us to be accorded, facilitated on different kind of trainings concerning human trafficking offenses. I have experience on judges being involved in trainings. Once Lawyers Without Borders came in Tanzania, and there was a training of prosecutors, investigators, and magistrates, judges. We all participated very well, and everyone appreciated and was happy. Then I think in Tanzania there will not be a problem in involving judges and magistrates on trainings. Thank you.
Thank you very much, Tanzania. Any more hands? Thank you, South Africa.
From my side, South Africa, I would also just like to extend our gratitude to the UNODC for creating this platform where we as neighbors could sit together and share our experiences and best practices. I think going forward, this could only better equip us, in fighting this scourge that we call TIP. And as indicated by Jeptun, most of our cases is we are going for the lower lying fruit. And I think moving forward, we must aim to go for the head. And it's always difficult to find the head, and the head is basically the one that's got the money, the one that's got all the resources that the lower lying fruit doesn't have. But I think sitting together in this room, sharing each other's experiences, we will go out there when we're in court, we will approach some of our cases in a different way. And I do think each of us are facing our own challenges when we go to court, but again, by learning from each other, going forward, we will be able to overcome these challenges. Of course, I think any challenge can be overcome if we just use the right tools to assist us. And we have the digest that we can go to. We have each other where we can, by way of email, phone call, get into contact with another and say, I'm facing with this issue, are you able to assist? And I'm speaking particularly now with the challenge that we in South Africa, and I'm referring to the Western Cape, are facing, is that when we have victims that are coming from our neighboring countries, sometimes because of the fact that the cases take so long to, even to come to court and to go to finality, some of our victims does not want to remain in safe houses. They don't want to remain here, they want to go back home. And once home, we have difficulty in tracing them. And then we have to either withdraw our cases, or if the case is already in court, you have to stop the prosecution, and that leads to another perpetrator walking free. Again, I would reach out to my neighbors. Please assist. I've got a victim that comes from Zimbabwe. I've got a victim that's maybe from Mozambique. Is there any way that you can assist the prosecution just to get that victim back to court so that we can continue with our case? And again, I would say thank you to the UNODC for creating this opportunity. I also do think that there's a need for our judiciary and lawyers to sit around in this type of setup to hear what is trafficking, to sensitize them. And it's not a question of us trying to influence them, but at the end, they are also judicial officers. At the end, they need to play a role in trying to fight this devil, if I may refer to it as that. And the only way that we can do that, or that they can do that, is to know what is this all about. Thank you so much.
Very well put, South Africa. Thank you very much. Looking across the room, any more hands up? I see a hand from Zambia or Zimbabwe?
Zambia. Speaking from the Republic of Zambia, would also want to thank UNODC for organizing such a training. Having listened to the presentations from the first day and reading through the digest, we've learned a lot and discovered that maybe this training should be as well extended to the judiciary, because when you look at the cases, especially from Zambia, we have the cases where this court decided in a particular manner, the other court again went into a different direction, but the same facts. So for us, we are thinking if even them are trained to understand the elements of trafficking, I think we'll have uniformity in the law, other than the other court gets it differently. And in one case, what I noticed even from the digest is that the prosecutors had difficulties to appreciate the offense of trafficking, in the sense that maybe this witness was just called and started just talking how he was gotten from this particular place to another place. But if the prosecutor understood so well that the elements to prove was what did they use, whether it was deception, coercion, for the purposes of exploitation, then what thereafter. Maybe if that is done, we'll really have a better decisions thereafter. I think in a nutshell, that's what I thought as Zambia would want to bring to the table. Thank you so much.
Thank you very much. Malawi.
Thank you so much, all. On behalf of of my colleagues from Malawi, first of all, let me thank UNODC for organizing this workshop. We have really learned a lot. I've gained a lot of knowledge, appreciated the skills which our fellow prosecutors apply in these cases. Above all, the digest and the cases which are contained therein. Much as these cases may not be binding on our courts in Malawi, but they will be persuading because the subject matter is the same. What we have learned in the cases will help us in making submissions before the court. We don't take this for granted. Otherwise, we were always searching within Malawi to get cases which are very few reported in our own country. So this has been really a great opportunity, and it will help us a lot in prosecuting these cases. With respect to training, I think it cannot be emphasized. Malawi is not an exception. I think we all realize that combating human trafficking is multi-sectoral. There are a lot of stakeholders that are involved. We, the prosecution, are just one of the stakeholders. But there are investigators out there that are very, very crucial. There are immigration officers out there that are very, very crucial. And the courts, of course. So joint trainings really will be so much appreciated, and we do want to implore upon UNODC to really support in this area, if possible, of joint trainings with the various stakeholders that are involved in combating this trafficking in persons. In addition to that, Tanzania, Malawi, Mozambique, and I think also it has been alluded to by Zambia, we also have this problem of trafficking involving especially Ethiopians and Somalians. It's our common problem. I don't know how you can help us as the 4 countries, because this is really becoming serious, smuggling people in containers. Sometimes even they are using a lot of concealments, ways of concealment that really you need investigators that are well versed with how to deal with these things in order to detect this type of smuggling as well as trafficking. So that's an area which I think we have a common problem as 4 countries. I think we can address it separately as an issue involving these 3 countries, but it's a critical issue. Don't know, we'll see how that we can be helped in that respect. Coming to Malawi again, in respect of issues of interpretations in cases where the victims maybe are outside the country and cannot ordinarily understand the language. That's an area also which support may be needed, as well as sometimes you have victims, especially with respect to the Ethiopians and Somalians. I mean, sometimes you find them, you keep them awaiting repatriation, but you find them, sometimes you keep them for long 6 months awaiting to find funds to repatriate them. It also becomes a problem for them as you are keeping them. They are not accused persons, they are victims. Therefore, readily finding means to repatriate them is also an important consideration. Otherwise, keeping them forever also, I believe, results in a traumatizing experience on their part. We would also like to point out that if possible, support, specifically in my country, in respect of review of the law. We have found the Trafficking in Persons Act of 2010, but I find our sentences to be on the lower side. We have been appreciating what the other countries have shared, sentences of 25 years, sentences of 35 years, but I think our act, the general sentence for trafficking is pegged at I think it's 14 years, and I think it's on the lower side as compared to the legislations within the region. That would be an area where I would be looking at reviewing the law, especially on the sentencing in respect of the general sentence for trafficking. For the trafficking of children, I think the sentences are okay. It's life imprisonment without option of a fine, so that's okay. But for the general trafficking in persons, the sentence is on the lower side, and will be working towards a review of that legislation. Again, issues about awareness. I think our Zambian counterparts talked about this, Sometimes these offenses happen in the community, but people are not able to point out that this is an offense. You have families keeping underage girls that are caring for their kids, that have been brought to these families, sometimes through illegal means. And I believe a general sensitization program to the community or to some of the stakeholders involved may address some of these issues. Another issue worth a consideration in my country would be the issue of even the cases that are decided, especially by the lower courts. If there is a program or a project to ensure that they are brought before the higher courts for reviews, confirmations, to make sure you develop a jurisprudence within the country of cases of human trafficking. All of us, we are aware that these legislations, they are almost, for most of our countries, they came after the year 2000. They are quite recent. They are not more than 20 years. They are not more than 30 years. So the jurisprudence is not as rich. Therefore, having a deliberate project of having cases decided in the lower courts, brought before the higher courts for confirmations, so that it gives that case law in this area, that jurisprudence in this area, it may be a very important exercise. Otherwise, if these cases, in most of our jurisdictions, if they are decided by the lower court, they are not binding, they are not decided cases, as therefore they don't really give us much direction as far as using them as precedents in the courts is concerned. That will be all from the Malawi side. Thank you.
Thank you very much, Malawi. Very comprehensive set of recommendations there. Do we have any more? So we're now reaching the end of our slotted time. Oh, there's a hand. Oh, there's a question from somebody in the Zoom. Do you want to read it out, or will they speak it out?
Hello, can you hear me?
Please go ahead, we can hear you.
Yeah.
Introduce yourself. Oh, I was about to say introduce yourself first.
Oh, okay. My name is Chisomo Kaufuro. I'm actually serving as the rapporteur for this meeting. And just to say, it's been very engaging because I've been very interested, even as I was taking the notes. I'm also supporting UNODC as a consultant on some of their work in Southern Africa on trafficking persons. I just thought I could quickly add, I know we're out of time, so I just wanted to say that I think one strategic area to also look into, even though it's a very political area, would be the aspect of corruption around our borders. I don't know how best, of course, strategies can be formulated around this, but I think there should be a way in which we can strengthen our immigration and border control systems to ensure that there are some form of accountabilities or mechanisms to monitor that people are not passing through as easily as they are, particularly in the case of minors, which we're seeing is a big issue. And even though there have been systems in place where when you're traveling with a minor, you have to provide an affidavit, I don't think it's working as effectively. And we're still seeing a lot of minors that are being crossed across the border with people that are wanting to exploit them. So I think we need to look up around the aspect of corruption and how we can support our immigration systems to tackle that. And also, I just think that we need to be thinking ahead now with the war in Ukraine and Russia. We are having an upsurge in living costs around the region. And this is going to be a push factor in terms of even increased smuggling of migrants as well as trafficking. And I think we need to be prepared for this. I think what our colleagues in Zambia were saying is true in terms of the multitude of smuggled migrants that are coming through. So I think we need to be thinking through around cross-border management and strengthening light of the soaring living costs across the region. Multi-sectoral labor inspections, I thought that was an important aspect that also was raised with Rahel, because police are not normally going around factories and checking for these things. I think we need to work very closely, strengthen the capacity of our labor inspectors, but also how they can work with other sectors such as health, such as the police, the labor officials themselves, and social services. So I think that could be a strong angle to look into. Regarding the training on judicial officers, I thought I could just add that a good strategy would be using other judicial officers, such as Justice Mwale herself, those who are well versed in issues of trafficking, to carry out these trainings so that perhaps there's a degree of acceptability. And when we are studying cases, maybe we don't take particularly the cases from that particular country where the judges are from, because sometimes they can be defensive in terms of how particular cases were decided. So you can take some cases that are from the region, but that are similar to some of the struggles that are happening within that particular country, and sort of highlight some of the challenges, the weaknesses, and what could have been done better. I'm just thinking that they are more receptible to hearing from fellow judicial officers, and also maybe for engaging on cases that don't necessarily involve them or their counterparts having decided on those cases. So I thought that could be a strategy. And lastly, I think maybe we also need to strengthen the intelligence-led investigations. Maybe that would be a good way on how we can start capturing masterminds. So we need to have a systematic way of looking at patterns and looking at risk factors through a multi-sectoral angle. Maybe that will help us to be able to catch the bigger fish as opposed to the middlemen. So I thought I could just highlight that, but also just to thank you all for such an engaging discussion. Thank you.
Thank you very much, Chisomo. Very apt, concise, and strategically to the point. So thank you very much for those additions. I will, in a minute, be handing over to Jeptam because we've gone over the time that we set ourselves for lunch. But it would be amiss of me to leave you without also expressing my gratitude. Every time I engage in these issues, I learn something new, and I've learned so much from the participants across the floor. Your wealth of knowledge, the experiences that you've had are absolutely amazing. And as a trainer at heart, I always introduce myself as a trainer, trading as a judicial officer. So as a trainer at heart, I'm always very interested in your case studies. So, a number of you have been approaching me with issues that you're having, this case and that case. If we haven't finalized, if we haven't sat down and you haven't given me all the facts, please share them with me. Whilst we may not come up with a solution right away, those become case studies for trainings. And as we present them in other trainings, other colleagues come up with solutions that I might not have thought of on my own, and then I filter them back to the people. So I am giving out my details. If you have any cases that are complex, please email me your case. Those case studies will be shared. Of course, we never mention what country they are from, but they are shared as hypotheticals. And at the end of the day, we're able to get a consensus of views about what you can do, what's missing, how to approach the court. So please set about scribbling. And thank you to UNODC for this amazing initiative. Thank you to Rahel, who always manages to amaze me with her infinite knowledge, because even the way she compartmentalizes her thinking, because these issues are so cross-cutting. The moment you mention consent in one case, it's already pointing to a number of other issues, and it's so difficult to write about issues that are so multifaceted, but Rahel manages it in such a way that we can understand it, see where she's coming from, and see where she's going. So it's such an honor to work with the guru on trafficking. Thank you very much, everybody.
Thank you so very much, everyone, for a wonderful 3 days. I would like to just take 1 minute to just wrap up. We've taken note of the recommendations around the room, particularly on need to have focus on trafficking for organ removal, particularly the issue of the albinos, which is really prevalent and has been really requires action. So we take note on that in addition to everything that was said. Finally, we'll not have a closing ceremony. I just wish to before we close, before we leave, just extend my sincere gratitude to, as was mentioned first, Rahel, who was the drafter and the pen holder for this wonderful work. I must say this assignment took 1 year. Initially, when this was brought to my attention, I took a step back and I thought this was an impossible task. And then I wrote to Rahel and we spoke, and I thought it would take 2 months. Then I thought it would take 3 months. Then it went 6 months, and then 1 year. But at the end of it all, I understand how it took 1 year of a lot of people's effort. So I really thank Rahel for her patience and her intellectual capacity and property on this. I also would like to thank Lady Justice Mwale, who's joined us. She really takes a lot of time to work with us on trafficking in persons, human rights issues, gender issues. And, you know, for those who do not know her, you could pass her on the street, you'd not know she's a distinguished honorable judge. Even if she was just speaking here, I would not know her seniority. So with all her humility, all her grace, we really thank you for your time, for standing here with us. And you know, we hope that in future other judges can emulate you so that we can have an easier time even when we go and ask for partnership, not training, partnership. I would also like to thank Chisomo, my colleague Banele here, who've also worked very hard in the background, and Oba Keng. Most important, I would like to thank you, colleagues, for taking your time to travel, putting aside your work to come and be with us here for 2.5, 3 days, including the 2 days of travel, 1 week out of your schedules. We do not take it at all for granted. You have taken your time, you've put aside your work, you have given us your significant contribution and your brains and your thoughts and your wisdom, which will be very useful in helping us move this forward. We really, really thank you all so very much. We'd also like to thank the colleagues who contributed to this digest, your colleagues who, most of them were not able to make it here, some joined us virtually, some were not able to come, and we'll engage them in the subsequent sections. There was a lot of probing emails, I wouldn't say harassment, but it sometimes bordered on harassment from us. We thank them all really for their time and their efforts. Would like to now thank, to a significant level, our partners who have really helped us. Without all this, it would not be possible. A lot of people say UNODC, but behind UNODC, there's a lot of help and partnership that comes together to ensure this is possible. One of them is the European Union, led by Pablo. I think he might be joining online, I don't know. They are giving us financial assistance to the SAM project to co-contribute to this initiative. I would also like to give us a significant level of gratitude to the United States government, represented here by Melissa and Sydney. Melissa, a lot of you may not know her, but she's sitting quietly at the back there, but she's really been instrumental over the last year. She was based in Washington, and now she's come to us here in South Africa. I think it's good so that you don't have so much cold, so she can come and enjoy this Southern African hospitality while we bother her with work and also ask for funding to move this forward. No pressure. Yeah, so really, I just want to thank you so much, Melissa, and the United States government, JTIP, for this partnership, which really without their support would not be possible. I'd like to end there, and I would like to say that Digest is here physically. We are printing more copies. If you'd like, you're one of those who like to read physical books, we're happy to share this with your colleagues. If you'd like, please reach out to us. We'll give you a few copies. It is also available online on our UNODC Regional Office for South Africa website, on our UNODC Global website, in all languages, Portuguese, French, English. If you do not find it on the UNODC website, I am happy to give it to you on flash disk. More reader-friendly. We've made it into an ebook, so you can flip, control search, easy, copy-paste, so it's easy for you to make reference. So whichever way, if you'd like it for me to send it to you or put in a flash disk or get it on the website, I'm happy to facilitate that. Finally, we are here for your service. If you need anything at all, any support on trafficking in persons, I will reach out to you if you're allowed to really seek your guidance on how to navigate engagement with partners, so that your partners in your member states, so that we can move actions on trafficking in persons and smuggling of migrants forward. My contacts are here with my card. phone number, email address, and I really put myself at your disposal for your guidance and anything that you might need. Thank you so very much. Really, we end here. We made it a bit late, 2 o'clock, but we hope that you can enjoy South Africa for the remainder of the afternoon and evening. Thank you so much. My colleague Obakeng will be here from 2 o'clock to finalize on the administrative financial issues and anything else that you may require. Thank you, safe trip, and hopefully see you all very soon. Thank you.